morning, everyone. This is the Senate Judiciary and Public Safety Committee. For the record, this is Friday, March 25th, 2022. We have a number of bills up today, 7 to be exact. 3 will be voted on. Numbers 2, 5, and 6 will be voted on. The others will be laid over for further discussion. We're going to begin with Senator Housley, Senate File 2857. Good morning.
Good morning.
Welcome to the committee.
Thank you, Mr. Chair and members.
Why don't you present your bill, Senator Housley, and then we'll move on to your testimony.
Perfect. Thank you. Senate File 2857 raises the amount designated for the statewide Minnesota Family Resiliency Partnership by $30 from each dissolution filing and $30 from each marriage license filing fee without premarital education. This reflects the amounts without increasing the overall filing fee paid by the applicants. For 40-plus years, the Minnesota Family Resiliency Partnership, previously known as the Displaced Homemakers Program, has been a trusted pre-employment and family stabilization program provided by a network of 6 regional partners across the state. It is the only program in the state specifically designed to help displaced homemakers address the unique barriers they face while trying to re-enter the workforce as they navigate a very personal loss of death, disability, or divorce from a spouse or partner. I've got 2 testifiers. Jean Keenan's here with me in person today, the Executive Director of the organization.
Ms. Keenan, welcome to the committee. Would you identify yourself first and then proceed with your testimony?
Mr. Chair, members, my name is Jean Keenan, and I am a provider in the Minnesota Family Resiliency Partnership. Thank you for allowing me some of your time this morning, and thank you also to those of you who were able to meet with us earlier to learn a little bit about this program, and a special thank you to Senator Housley for authoring this bill and being such a strong advocate for our program. This wraparound program is offered at no cost to participants, all of whom are at or below 200% of the federal poverty guideline. Each individual works with a provider to develop a unique action plan. So we teach participants the essential transferable skills they will need and help them develop effective job search strategies. Additionally, we provide limited direct support dollars to help participants overcome barriers. Finally, and I think most importantly, the program helps families to stabilize after a crisis by providing holistic and trauma-informed care. The average length of time in the program is 40 weeks, although participants are eligible for services for up to 12 months. According to the data from the most recent fiscal year available, 60% of displaced homemakers served by the program were victims of domestic violence. Of the participants with a child support order, 75% were not receiving the support as ordered by the court, and 22% entered the program homeless. This program serves a population facing multiple barriers. The program results in excellent outcomes. 97% of participants successfully complete the program by attaining the goals they have set at intake, which include completing their steps in their self-sufficiency plan, pursuing a degree or certificate program, and/or becoming employed. As you can see from the bill, funding for the program is authorized by statute and administered through deed from a small amount of the fees collected from marriage license and divorce filings. This structure was specifically designed for this program alone. The amount collected from these fees was the program's sole funding source from 1982 to 1992. There was a brief period during which the program was funded through workforce development or general fund dollars. However, in 2003, it was recommended we return to the use of these fees as our funding source once again. This continues to the present. There has never been a request to update the amount collected in the program's long history. As you can imagine, the cost of providing services today and going forward is much different than it was several decades ago. When DEED sends out a request for proposals, $3,000 to $5,000 is considered an acceptable annual cost per participant. According to their formula, the cost per participant for our program is $1,498, significantly less than any other program. It is projected that the requested update to the statute would bring our program in line with the lowest end of that range, but it makes current services continue to be feasible at a time when they are desperately needed. The services we provide are critical because those who participate in the program are often Minnesota's unseen, unemployed, or underemployed who may not otherwise receive any services. I want to thank you again for your time and consideration of Senate File 2857. And then with me today via Zoom is one of our past program participants, Stacy Gordon, who will share her experience.
Thank you, Ms. Keenan. Ms. Gordon, she's remote.
Good morning, everybody.
Good morning.
Mr. Chair,
Would you identify
members.
yourself for the record and then proceed?
Yes, hi. My name is Stacy Gordon. Thank you for your time and allowing me to be here and testifying before you. Prior to the program, I had been in an unsafe relationship, and I knew for the safety of myself and my children that I had to leave. I moved to the Brainerd area, not knowing anybody except for a few family members in the area. I didn't really have any support, and I felt lost. I was now a single mother of 4 young children and was desperate to be able to provide for my family and create stability in our lives. I found out about the Minnesota Family Resiliency Partnership program and enrolled. From the very first moment that I met with the director, I was showered with love, hope, and support, something that had been very lacking in my life. I was provided a supportive environment for me to pursue my education and career goals. I attended and benefited from the various workshops and support groups. The different activities and things that we learned and discussed, such as grief support, self-esteem, goal setting, resume writing, job interviewing skills, communication skills, were all very helpful to me. Also, the computer lab was extremely beneficial to me as I had 4 young children at home and it was very difficult for me to get anything done. And it provided a nice, quiet workspace for me. Because I had lacked confidence and support, I felt like I did not belong in college. This program helped me to assimilate into the world of academia at Central Lakes College. One of the biggest goals that this program helped me accomplish was to get my driver's license. I had a lot of fear and anxiety about driving. This had always been a significant barrier to me and my family. My 4 children and I walked everywhere we went, rain or shine. Though we did what we had to do, walking in the cold and such was just really hard on us. I had little to no driving experience. And the program director gave me the gentle nudge to finally take the step and take my road test. With her support and the newly found confidence in myself that I could actually do it, I passed my test. I am now a confident, independent driver. We no longer have to walk anywhere, take a bus or a cab, or bother anybody for a ride. It is such a huge freedom. I had no idea how big of an impact it would make on my family. Another major goal accomplished with the help of the program was getting a car. The program was very instrumental in helping me apply for a grant for a donated car. I was so very happy to be chosen the recipient. I can also now happily say that I am a college graduate and I'm gainfully employed in a career that I love, where I can help and support others to reach their goals and provide for my children and the grandchildren and my 3 grandchildren who I'm also raising. I'm so very thankful and grateful for the services that this program has provided and for all the support that I was given. This program has helped me in so many ways, and it has changed the course of my family forever. Thank you.
Thank you. Is there anyone in the audience who wishes to speak for or against this bill? Hearing none, we'll open it up for discussion for our committee. Senator Bigham?
Thank you, Mr. Chair, and this is a fantastic program, and I appreciate Senator Housley bringing this forward. We heard it in civil law last week, and it is a very useful program, and I'm happy that we're discussing this today and it's moving along. Mr. Chair, I have the A2 amendment at this time I'd like to offer.
The A2 amendment, is that being passed out or is it in our packets? It's being passed out.
Yeah.
So would you want to describe it as the
Yep.
amendment is being passed out? And Senator Housley will need one too.
Mr. Chair, last year,
Senator Bigham.
thank you, Mr. Chair. Last year, the Civil Law Committee unanimously passed a bill that allows counties to accept marriage applications signed by both parties by mail, fax, or electronic filing. We did this as a result of the pandemic, but what we found is that it's very efficient. And we extended it once in a bipartisan manner, and then it sunsetted, and we haven't extended it again. Scott County, and I have been working with Senator Pratt on this, as long as your county of Hennepin County are very supportive of this and would like to see this a permanent option for counties because it is a cost savings and efficiency manner for them. The Association of Minnesota Counties supports it, and MICA supports it. So I've asked for hearings. I think it's a very bipartisan approach. We've done it before. It works. It's helpful. And I'm hoping that we can get consideration today, and I would be interested in Chair Matthews' thoughts on the amendment.
Sir Matthews, are you prepared to give us your thoughts on this?
Mr. Chair, no, I wasn't preparing any statements on this. Mr. Chair, are we voting on this bill today, or is this one that we're laying over?
Well, on the bill itself, we will be laying over this bill.
Yeah. I'm sorry, counsel was speaking to
The
me.
bill itself will be laid over today. We are not voting on the bill.
Right.
You have an amendment before us for consideration. Senator Matthews apparently is not prepared to make a comment about your amendment. But I do have a question. Is there a cost factor to your amendment?
Mr. Chair, no, not that I'm aware of. There wasn't last year at all.
Mr. Turner's nodding no.
Yeah.
So,
I'm a fiscal conservative, Mr. Chair, so I don't like to spend money, you know that.
all right. Senator Housley, do you have an opinion on the amendment?
Yes, Mr. Chair, thank you very much. I don't think it's a bad amendment. It's just that we have worked so hard with the Minnesota Family Resiliency Partnership to get this bill to where it's at right now. I wouldn't want anything to slow it down. And it hasn't had a hearing in Senator Matthews' committee. And so this would take this bill and have to move it back to another committee, I assume. So I would prefer to not add it on today and to leave the bill clean as it's gone through civil law already. But I'm more than happy to talk with Senator Bigham offline. Maybe going forward, we could do something in Senator Pratt and Senator Matthews to her amendment.
Mr. Chair.
Senator Bigham.
This did pass unanimously out of Senator Matthews' committee last year, and I believe due to, is it Rule 47, that it was just sent back to his committee, but it actually made it all the way to the floor. And it is, I believe, moving in the House as well. I do not want to do anything to slow Senator Housley's bill down, and I appreciate the offer of discussing this offline so that maybe we could continue to work on it and find a different place for it to be attached. So with that, I will withdraw the A2 amendment.
Sarah Bigham withdraws the A2 amendment. I know that Senator Giffmeyer is remote today. She wanted to make a comment, I guess, on the amendment. Senator Giffmeyer, now that the amendment's been withdrawn, do you want to continue the discussion?
Mr. Chair, it was on the bill itself, not
All right,
to the amendment.
go ahead. Go ahead if you.
Okay. Well, Mr. Chair, the question I have for our testifier, I'm so sorry, but I didn't quite catch her name. But in regards to how did she find out? I mean, what a great story of a success in this program. It's really commendable, especially the efficiency with which they are running this program. That's commendable. But I'd like to know, how did this testifier come to find out about it? I mean, how did she do that?
Are you talking about the second testifier?
Yes, yes, Mr. Chair.
That's Ms. Gordon. And
Ms. Gordon, please.
Ms. Gordon, are you still on with us?
Yes, I am.
Senator Giffmeyer, could you repeat the question for Ms. Gordon.
Sure. Thank you, Ms. Gordon. I so appreciate what you've told us about your experience, not only the program, but obviously your fortitude, and what you needed to have was just some support along the way to realize it. But you had the capacity within you all the time. You just needed to have a little bit of help. You said you found the program, and I'm curious as to how did you find it? Was it a notice in the paper? How did you come to find the program?
Ms. Gordon.
I had enrolled at Central Lakes College, and that is where Meta 5, the Minnesota Family Resiliency Program, is housed. So I had been hearing from word of mouth from another person that had been in the program, and she was telling me about it and how much it was helping her. So, and then I spoke with the director at one of the events that they were having, and it just really sounded like something that would be of benefit to me and my family. So I went ahead and applied, and it was really, really what I needed in my life, my kids' life.
Senator Giffmeyer.
Thank you, Mr. Chair. I just really feel that both the program and this person, but sometimes when they're in these circumstances, it's very hard to find the help they need. So I was glad to hear that. At any rate, Mr. Chair, I do support this and hope that we are able to find it to be included in our final bill. Thank you, Mr. Chair.
Thank you. I have a question. Ms. Keenan, when was the last time these fees were raised?
Mr. Chair, the last time the fees, well, they weren't actually raised, so we had from 1992 to 2003 moved back to a different funding source. I would imagine at the time that they reinstituted the use of the fees that there was an increase from the original, but it would be 20-plus years with certainty.
All right, that's important for me to consider. A lot of value of the U.S. dollar has changed quite a bit in 20 years. All right. Is there any further discussion? Senator Matthews.
Mr. Chair, we did hear this bill in civil law, and I thank Senator Housley and the advocates for working on this. I am very pleased with the results and the way that we were able to find a way to help this program out without raising the overall fee, which was an earlier proposal. And so I think we've got a really good bill before us today, and happy to support it.
All right. Any further discussion? Any closing comments? Senator Housley?
Yes, thank you, Mr. Chair and members. This is why I love my job. It's when people like Jean come down to the Capitol, and every time she comes down, she has another one of her clients that tells stories similar to Stacy. And to see a program that works so well and so efficiently on so few dollars, it just gives you goosebumps when you hear Stacy's story. And so it makes me proud that we have friends like this and programs that we can support. So thank you, and thank you, Senator Matthews, for pushing on through too. Thank you.
Hearing no further discussion, Senate File 2857 will be laid over. Thank you, Senator Housley,
Thank you.
and your guests.
Thank you.
We'll now move on to the second order of business, Senate File 3749, Senator Ingebrigtsen's bill. And members, this will be a bill that we will be voting on. Senator Ingebrigtsen.
Good morning, Mr. Chair and members. Thank you for the opportunity to bring before you Senate File 3749. Members, this is a private detective license requirement modification. And I do have a testifier with me, but before that, a little description of the bill. The bill requires the Board of Private Detective and Private Agent Services to accept proof of required pre-assignment training from employees of of licensed private detectives and detective agents if the training was provided by another Minnesota license holder within the past 3 years. The bill requires license holders to provide a certificate of pre-assignment training and employees even when the license holder paid for the training. Is a little bit of a tongue twister, Mr. Chair. Pretty straightforward, pretty clear. Mr. Chair, if I might, I would like to introduce Mr. Mcphee, who's the Executive Director of the Private Detective Board, who will be joining us remote for a better description of the
Yes, Mr. McPhee is the Executive Director of the Private Detective Board, and he will be addressing us remotely. Welcome to the committee, Mr. McPhee. If you would identify yourself for the record and then proceed with your testimony.
Okay, thank you. My name is Hugo Mcphee. I'm the Executive Director for the Minnesota Private Detective and Protective Agent Services Board. Thank you, Chair Limmer and Senator Ingebrigtsen, for allowing me to present this important legislation. It's a minor tweak to the existing statute. Essentially, the current language recognizes and states that 12 hours of pre-assignment training is required for anybody entering the private security or private investigatory industry. They must obtain that 12 hours of pre-assignment training within the first 21 days of employment, which makes sense, or evidence that they successfully completed it prior to the employment. The board, my board is represented by members in the industry as well as public members. And this has always been a point of confusion when we seek to relicense or recertify existing licensures with questions around the pre-assignment training. So the proposed legislation in front of you is relatively minor in nature, but it does make a great impact both for the companies within the industry for hiring new staff, as well as for portability for existing people in the industry. Number one, three bullet points briefly. The statutory change would require, or would recognize rather, that a new hire, if they could demonstrate completing this pre-assignment training occurring previously to their application with the new company within the last 3 years, that we would recognize that versus the 21-day requirement. So that creates a more portable career for people trying to move to different companies. It also makes it easier for companies to hire people without having them go through additional pre-assignment training. The average cost for pre-assignment training is around $300 to $400. So that's many times a needless expense on both the employer or the employee. Second bullet point, which is important, employers are required to provide their employees or former employees with a copy of their completion certificate regarding pre-assignment training, regardless of who paid for the training. We have heard stories where staff may have been employed for 5 years with company A, decide they leave for a better opportunity with company B, and they don't have copies of their certificates. So when they come to company B, either the employee themselves has to pay for the pre-assignment training as a condition of hire, or the new hiring company has to pay for training that was already received. So this clarifies that. And then lastly, the proposed language just gives some parameters as far as how long pre-assignment training exists for or is good for. So the three years is very much a helper in that respect. Even though we are a regulatory board in nature, I believe a big component of our job is to provide excellent customer service to the licensees and the people in the industry, as well as keeping communities safe as a supplement, not a supplantation, but a supplement to the work that law enforcement does. I have recently retired 31 years in law enforcement, much of it spent outstate, the last 16 as a chief before I came to the private detective board. And I see a lot of benefit coming for this for citizens in general. But that's a brief summary of the proposed legislation. I hope I was relatively clear. But thank you for your time, and I'll stand for questions if you have any.
Thank you, Mr. McPhee. There's no further testifiers listed. However, Senator Bigham, did you have a question?
Thank you, Mr. Chair. Not a question, but Senator Ingebrigtsen, thank you for bringing this forward. This is one of those unique areas of our statute that doesn't get a lot of attention, but does a lot of important work. And so it's important to kind of be reviewing these and listening, because these folks are used in such a variety of ways for companies, for family law, just totally a lot of different options. And so to have these statutes reviewed and updated so that it's more efficient and effective for people that are trying to transition back and forth, keeping that talent and people that have real life experience, such as yourself, Senator Ingebrigtsen, and others that are maybe transitioning out of active law enforcement to doing this and providing good services, to help companies and folks. So anyway, thanks for bringing this forward.
Is there any other discussion? Questions? Senator Anderson.
Thank you, Mr. Chair. Senator Ingebrigtsen, or to your testifier, can this fee, or I should say the license, the certificate, can this be utilized in other states such as the surrounding 5, Wisconsin, Iowa, or would they have to get other training from those states? Or maybe you're not aware of, maybe your testifier has some information on it too.
Senator Anderson, if I may, it would not apply in Minnesota. They would have to have training specific to Minnesota. However, as the executive director, I have been given the authority to review existing training from other venues. So if somebody did come in from a different state and had the curriculum for that pre-assignment training elsewhere, I would compare that against statute, and if it met, I would have the authority to approve that. So that could be a plus, but right now it needs a special review by myself.
Thank you.
Mr. Mcphee, my question would be if one of the investigators in Minnesota had an investigation that led him outside of Minnesota, does his authority or his investigative role stop at the border, or can he go beyond Minnesota, make his observations, and then return to Minnesota, or does he cancel his responsibility?
Chair Limmer, that's a very good question. Many of our agents are licensed in multi-state jurisdictions, so that in those particular individuals would not apply, but they would be limited at the border, and so they would either contract with another agent within Wisconsin, for example. There are a couple of statutory exceptions. So if you are working for an attorney or public defender, you have some more broad latitude. I'm not sure how Wisconsin uses that, but we could, in theory, encounter something like that. But the general rule is it would stop at the border.
All right, thank you. Any further discussion? Is there anyone in the audience who wishes to speak on this bill? Hearing none, Senator Ingebrigtsen.
Thank you, Mr. Chair and members, and Senator Bigham for the comments, and to the testifier. This seems like a very reasonable way of addressing the issue that the director wants to do, and I guess as much training as you can get for any type of job like this, especially like this, I think is certainly important, and we should all want those folks out there to be certified and licensed for sure.
Senator Ingebrigtsen, would you want to make a motion?
Mr. Chair, I move that Senate File 3749 be passed and recommended to pass and moved on to the floor.
Senator Ingebrigtsen moves Senate File 3749 be recommended to pass and move to the floor. All those in favor, say aye.
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 Opposed? The motion prevails. Thank you, Senator Ingebrigtsen. Stay there. We have another one of your bills, Senate File 4134.
Thank you, Mr. Chair.
This bill will be laid over.
Thank you, Mr. Chair, again for hearing the bill that came up kind of I guess they come up all the time during session, but this one just came up a couple of weeks ago. And the thought behind the bill, of course, was, and it would be nothing new to this committee, what we're talking about. Probably 75% of the bills are talking about police, hiring police, retaining police. You know, there was talk of reducing police a couple of years ago, and I think now what we're finding is that might have not been the right thing to do. So agencies are looking at hiring police back, those that had not only retirement but injuries and whatnot. So And police training was one of the discussions. And Chair Limmer, you were so kind as to put me on a committee a couple of years ago, and I think I've referred to that committee a couple of different times, but there were some good things that went on there. And there was talk about training and de-escalation training. There was talk about body cameras, and I think I've made it very clear that over the years, I've never kept up with the times when it comes to body cameras. And now whenever I talk to an officer out on the street, they say they wouldn't want to be without them. So it's those kind of things that have changed my direction in my, with my previous experience trying to stay with the times. And one of the things I also took from that particular meeting was Philando Castile's uncle. He was very animate about and wanted the committee to make a recommendation that all officers in the state of Minnesota wore body cameras. Well, when we started putting the pencil to that, it was a very extremely expensive ordeal. And I don't know if there's been any bills as such brought forward. I'm not sure. I guess we've kind of left that up to the agencies to move forward with that. But so I'm setting the groundwork for why I'm before you today, and that is about police training that exists now in Minnesota. You'll see the community colleges in your packet that actually does the training. You'll also see a list of departments where officers from just the Alexandria Technical College, which is the, in my view, the premier law enforcement training school, has been since early 60s. That's even before my time, Mr. Chair. But you'll see the percentage of folks that graduate from there are employed most generally in Minnesota. And I did not get the other agencies, the other community colleges as to where they are. Some of these are fairly new in the business of public safety. Alexandria Community College being the oldest, and I think the one that puts out the most officers. And this particular funding would be for a $5 million appropriation, Mr. Chair. And at this point, I could offer the A1 amendment, which I can describe.
Senator Ingebrigtsen moves the A1 amendment. Senator, this bill is facing its first jurisdictional committee, so this would be an author's amendment. Hearing no further discussion, all those in favor say aye.
Aye.
Opposed? Opposed? The amendment is adopted. But Senator Ingebrigtsen, could you explain your amendment now that it's part of your bill?
Yep, Mr. Chair, thank you, and thank you for allowing the amendment and for me to discuss it. The first original bill, as you can see, was a lot less dollars. I was at that point in time targeting funding for just the Alexandria Technical Community College. After further discussion with folks in the higher ed area who obviously are interested in this as well, they said we should be probably looking at all schools, and in all fairness, that's exactly what we should be doing. I didn't realize what kind of funds that would be. I came up with this number from the higher ed folks, and it would obviously take in more than just the Alexandria Technical Community College. And I think it's distributed according to the number of people operating in the skills program. The grants will be used for technical needs, including body cameras. I don't know that there's any of them that are being used. I don't think any of the schools have them now. And when we're so insistent on having body cameras, we ought to be training on that particular area too. So to enhance this, the student learning through the real-time review, fleet vehicles, some of the vehicles they're driving are almost, some of them shouldn't even be on the road. Some of them just are used on the track, but they just need to upgrade their equipment. Automatic vehicle locators, light bars, radio racks, de-escalation simulation program, that's an interesting one. You know, these simulation programs, and I'm sure you've seen them around before, good guy, bad guy, shooting things. This is about de-escalation, which was a lot of discussion we had in that committee as well. You have somebody in the corner just because you are armed and they may have a knife, you work real hard to get them out of that corner without assaulting anybody, and you use your verbal skills and other techniques, and this is a simulated training program, and if they wish to have that, if they don't have it, this would cover that. So that's a 360-degree simulator. I mean, I haven't seen that, but I can about imagine what it is now. And recording equipment and iPads for crime scene investigating scenarios. I mean, every squad now has computers, and these officers, these potential officers, need to be trained on those things, so they're ready to go when they get employed. And we all know that the agencies now are having a hard time finding folks qualified or even willing to go into the field of law enforcement. And I think that this is an encouraging move on the legislature's part to not entice people, but to show them how serious we are about our people coming out of school and going into this what has become a very contentious profession. So with that, I'll stand for questions. I do also have a testifier who knows way more about this than I. He was the administrator at the Alexandria Community College, and now he's vice president of academics and student affairs and professional police officer education coordinator. So if I could indulge the chair and the committee for Mr. Berger to testify, I would like to do that right now.
Mr. Berger, you're remote. Are you online?
I am.
We can see and hear you. Why don't you introduce yourself and then go on with your testimony.
Well, thank you. I'm Scott Berger, and I am with the Alexandria Technical and Community College. And as part of that role, I'm also the post-board coordinator for this program, of which I'm sure many of you are aware, all of you, that every post-approved licensure program in Minnesota is required to have a coordinator. And I've been in that role since 2006. Just to correct Senator Ingebrigtsen, I'm not way smarter and more knowledgeable than what he indicated. So I'm trying to lower the bar just a little bit for myself. But Chair Limmer, I appreciate the opportunity to be here. Senator Ingebrigtsen, he is an alumni. He is one of the earlier graduates of this program. And I came well after him, but a longtime supporter of law enforcement education. So I just really appreciate this coming forward. And probably more importantly, I'm honored to be here to represent the 9 other psychomotor education, or commonly known as skills providers, of which I believe that this bill and the amendment to it are supporting. There is a strong need for this. And skills providers, what we focus on is scenario-based training. So for those of you, I don't want to be presumptive, for those of you that may not be familiar with the system, in higher ed, we have a tendency to talk in a language that we're probably mostly the only ones that understand it, and acronyms. So I want to make sure that we're on the same page. So a student wanting to get into law enforcement must go through a PPOE program approved by the Post Board. And that is a 2-prong education. One of them is the academic or the lecture side of the house, the more theory-based. And then you have the psychomotor or the skills scenario-based portion. After completing both of those, you're then eligible to take the licensure exam. What I'm looking at, or what this bill, I believe, focuses on for the Min-State system and the 9 institutions, is enhancing our delivery of the psychomotor skills. Scenario-based training is an extremely valuable way of teaching because it applies and inoculates a student to stress prior to being put in that position. So when Senator Ingebrigtsen was speaking of The simulator, for instance, we can apply stress to a student, requiring them to respond at various levels within a force continuum. De-escalation, that permeates throughout all of it, with the end goal of using, in an example of force, using the least level of force required in order to resolve the situation without any harm. Now, sometimes that escalates. Switching over now to the body cams, the recording equipment that's listed in there. Real-time accountability is extremely important. And for students, we have a chance to not let them play through the entire scenarios when we put them into, and then wait till it's all over and they've completed it, maybe having gone down the wrong path. We can stop them. We can explain and say, okay, this is what you did. Where did you go wrong? And then we can restart the scenario, but we can also replay it live for them. Because most of us under stress don't remember everything that transpired, even though we think we might. And this gives them that opportunity to realize what they didn't even remember saying or what their body language may have displayed. So I guess I should just probably be quiet now and answer any questions you might have, because I could go on forever about this.
Mr.
Thank
Chair-
you, Mr. Berger.
Mr. Chair, he's right. He could go on forever.
Senator Giffmeyer.
Thank you, Mr. Chair. One of the things that my in the other body, my House member, who is a retired sergeant from the Sheriff's Department, and of his comment about multi-jurisdictional training, that many times, especially these days, you might have someone fleeing or a variety of situations or it's a very large kind of action, but you have multi-jurisdictional. Could the testifier from Technical College, Mr. Berger, could you comment on, do you include such multi-jurisdictional, or maybe with students in this situation that is maybe an advanced kind of training, but nonetheless, if you would just comment about that area or how these funds could possibly be helpful in that regard.
Mr. Berger.
Well, Senator Giffmeyer, thank you for the question. I'll do my best. Multi-jurisdictional training is an extremely important thing because you're bringing in different agencies, sometimes different policies, sometimes different internal practices on how this is how we do it here, but then they all come together at the point of crisis. And so this would enhance that. So we do pre-service, and that's what my previous testimony was mostly about. But I think virtually all of our skills providers or psychomotor providers, we provide in-service training as well, which is what that falls under. So these facilities have multi-uses. Here at our institution, some of you may remember this because you were involved in the approval of the new building in 2000 that finished in 2009 here, as well as at Hennepin Tech. It was designed in a way to allow 24/7 access to agencies that needed to train, so that when classes were not being held, we could open it up electronically and let them come in and use it when no one else was around. The premise being, if we can't trust them to be in our state building, who are we going to be able to trust in the state building? So, and we have never had a problem. We have had multi-jurisdictional agencies train here in the past. We've had outstate agencies that have come in and rented our facility so that they could do training. We've had specialized tactical training that consisted of agencies from across the state, as well as federal agencies utilize this. So we're really good at opening up our doors to enhance the education for this profession. From when they walk through the doors as an applicant to the point when they've been in it for 15 or 20 years.
Mr. Chair.
Senator Giffmeyer.
Yeah, thank you very much. I really appreciate that because I think ongoing training is really important, and this multi-jurisdictional is increasingly a part of a very important consideration. But I'm very grateful. I think we need graduates from these programs that are ready to function more fully, have that highly skilled level training, which I think in these days is required. So thank you, Senator Ingebrigtsen, for this bill. And I'm hoping, Mr. Chair, I know we have limited funds and all these things that maybe we can and in the future even consider it more strongly. Thank you. And thank you, Mr. Berger.
Thank you.
Thank you, ma'am.
Senator, Senator Pappas.
Whoops. I have something on. Right. Thank you, Mr. Chairman and Senator Ingebrigtsen. I just noticed that there's only one training program in the metro area, Hennepin Tech. And I was just wondering why there aren't, if you have any idea why there aren't more at our other community colleges, and does it have anything to do with like Minneapolis and St. Paul operating their own academies? Or do students usually do the 2-year program and then go into an academy? I don't know, and I don't know what the metro counties do either, but I was wondering if Senator Ingebrigtsen has any idea.
Senator Ingebrigtsen.
Mr. Chair, I have some idea, but again, Mr. Berger has been in the system, with the system a long time.
Oh, maybe Mr. Berger
And
knows.
I believe I can say that Hennepin Technical is also probably the second largest next to Alexandria. So that's about all I know, and why they are where they are, I'm not sure, but I think Mr. Berger could answer that.
Mr. Berger, would you weigh in on that question?
I'd be honored to provide my little bit of tidbit. Thank you for the question, Senator Pappas. So if we go way back to the beginning of licensure requirement, post-secondary education requirements, 1967 is when Alexandria started. And that was 10 years before there was ever a post-secondary education requirement. That was followed up by Hibbing and then followed up by Minneapolis. So there were 3 providers of law enforcement education. It expanded over the years to include a consortium being created in the metro area that consisted of Minneapolis providing the skills or psychomotor training for other institutions within the metro area. Inver Hills, Century, Normandale, and some others that I can't pull off the top of my head right now. And then outstate ones were created later and added to the mix, with the goal of enhancing and increasing, I believe, the number of candidates available for agencies. And so I think that's why the limited locations came in. There were schools that would apply, and they would need to be approved by MnState, but they also needed to seek approval by the Minnesota Post Board. And for a while, there was a moratorium on skills programs within the MnState system because of capacity and because of cost. And this was really around the area in which equipment supply budgets were being reduced because of overall budget restraints and restrictions. So if I went off on a tangent, I apologize. Did I kind of work towards the answer?
Mr. Chairman, yeah, I did want to know, though, if you could tell me, then what do police officers do? They have to go to one of these training programs for 2 years or 8-9 months, and then do they go into a police academy, or is it's both? That's what I want to know, both or either or.
Thank you, and I apologize for missing that. I didn't have that jotted in my notes. So there's a variety of ways to get into law enforcement through and into licensure. The programs throughout the state, within the MnState system, as well as the privates, if they're post-approved, you have an Associate of Applied Science degree in which it incorporates the academics and the hands-on learning. There are Associate of Science degrees, which incorporate the academic learning, and then you go to a skills program. There are universities that provide the academic portion up to the bachelor's level, and then you attend a skills program. After you've completed that post-requirement, if you are employed by an agency, you can then be required to go to their academy if they're an agency that requires that, whether it's the Department of Natural Resources, Minneapolis, St. Paul, I believe St. Cloud may have some sort of similar academy now that they brought forward a few years ago. But then there are some, Hennepin Tech has an arrangement with agencies within the metro, with certain ones, where they facilitate getting that student or person through the academic and skills in a uniquely created way. And I put it that way because I don't know the exact specifics of how they do that, and I don't want to say anything that's inaccurate.
Thank you, Mr. Chairman. Mr. Berger.
Senator Anderson.
Thank you, Mr. Chair. I'm wondering if this, the amendment that you've got, Senator Ingebrigtsen, would apply to, let me give you an example. In Buffalo, we have what they call the Wright Technical Center, and I was just informed last Friday when I met with them that they have a law enforcement class that they provide for students, and I think they said 9 or 10 students that come to their class for that. But I also know that my step-grandson took a welding class through Wright Technical Center while he was a junior and a senior, and then he had to go to a technical school, like is mentioned here in this amendment, to get his 2-year certificate in welding. I'm just wondering if this would apply for funds for a Wright Technical Center that are dealing with law enforcement students. Maybe Mr. Berger has an answer for that too.
Senator Ingebrigtsen, I'm going to go to you first.
Mr. Chair and Senator Anderson, thanks for that question. Are these, not understanding, are these high school kids that take this test?
Senator Anderson.
Okay.
Senator Ingebrigtsen.
I'm just going to go out on the limb and say, no, I don't think this money would be utilized for that, and I might be wrong, but I'll again turn over to Mr. Berger. This is really talking about equipment for those that actually train for the actual license itself. But I'm guessing no, but I'll ask Mr. Berger to answer that.
Mr. Berger, any contribution?
Thank you, Senator Anderson, for the question. I certainly don't want to speak on behalf of the Senate on what this should be used for, but I might be able to explain that we have agreements here in Alexandria with Wright Tech, and we also provide them with equipment that once it's used up here, we have an offer to provide it to them as well as other schools. What they provide is an introductory coursework into law enforcement with the hopes of enticing them into the program or getting their interest into it or defining it and identifying it. And then we provide a certificate in such a way that we can accept that course in credit towards our program should they decide to come here. So if they take an Intro to Criminal Justice course at Wright Tech or at another tech college affiliated with a high school, that credit is transferred into this institution. And the learning objectives are aligned. That's all done through CTE, Career and Technical Education, experts that facilitate that process.
Thank you, Mr. Chair.
Senator Latz.
Thank you, Mr. Chairman. Just following up on Senator Ingebrigtsen's comments about the availability of funding for body cameras around the state. Obviously it's a terrific advantage for everyone in the system. It holds police officers accountable and protects police officers against unfair allegations as well. And it ends up being used in court and in criminal charges frequently, and I would say far more often than not, it eliminates factual questions or defenses that might be otherwise asserted when there's video camera footage that shows otherwise. It ends up benefiting the prosecutors far more often in those cases, the prosecution of the crime. So a great advantage. I will note that there is a very conscious effort to try to expand the availability of body cameras across the state. I think most metropolitan agencies do have them now, or they're in the pipeline. I will note that in the governor's public safety bill, there is a line item for $1.5 million to provide body-worn cameras for security guards in the Department of Corrections. And in the governor's transportation bill, there's $6 million in this fiscal year and $3 million in the tails for body-worn cameras for law enforcement across the state of Minnesota. So there's a very conscious effort to have funds available so agencies won't have any fiscal excuse for not implementing body cameras throughout their forces. Thank you.
Senator Latz, I recall Senator Duckworth had a bill before us. We laid it over for body cameras as well about 6 weeks ago. So I think it's all on our radar screen. Thanks for bringing it up. I had a question, line on the amendment, Senator. Page 1, line 11, perhaps. This is more for counsel. We're making reference to the word iPads. Is it appropriate for us to mention a specific commercially licensed product? If we continued that in law, are we awarding a contract to people who make iPads by that reference?
Mr. Chair, members.
Mr. Backus.
First off, this is not a codified provision. This will be a non-codified provision, and there's no requirement that they actually use iPads. It says this type of equipment such as iPads. So it gives them the option. If you're more comfortable, you could delete iPads and insert such as electronic tablets if that would make you feel more comfortable.
Senator Latz, would you entertain that as a motion, an oral amendment? Senator Ingebrigtsen, do you have an opinion?
No, that's fine.
All right. Senator Latz.
Mr. Chairman, I'll move on page 1, line 11 of the delete everything amendment that we have adopted, that we strike the word or delete the word iPads and insert in its place electronic tablets.
Everyone understand that as an amendment? All those in favor say aye.
Aye.
Opposed? The amendment is adopted. Any further discussion by committee members? Hearing none, Senate File 4134 will be laid over.
Thank you very much, Mr. Chairman.
As amended. We'll now move on to Senate File 1462, Senator Westrom. Senator Westrom, I see you have brought a guest with us, and you have one remote as well. Why don't you tell us about your bill before us?
Mr. Chair, members, appreciate your indulgence, Mr. Chair, and the ability to review Senate File 1462 with you. Members, I'll try to be brief in the recap so my constituent Joyce has time to tell you a little about her situation and others that have similar situations. But this bill would have two parts. One, it would establish a guardian bill, a bill of rights for patients or persons under a guardianship. This is an area that for years has always been a delicate balance concern. Guardianship is a very serious business, and when somebody has limited capacities or sometimes no capacities at all to make everyday decisions or healthcare decisions. This is a very important part of the law, and so this would establish a Bill of Rights and make it a gross misdemeanor for a caregiver or legal guardian to prevent a person from exercising one of their rights under this Bill of Rights. And so that's Section 1. Ms. Lacey, who's here to testify here today, and I'll let her talk a little bit more about it, but she experienced a situation with her mother and her guardianship that they were very concerned at how she was treated, and she's talked to many others and having similar concerns. This bill originated with Representative Bud Nornis, who Joyce had originally worked with, her mother, who has passed away. We used to work for Representative Nornis in the radio station business years ago, and he knew them fairly well. And 3-4 years ago, I'd worked up a draft and talked to me about carrying it here in the Senate as well. And so that's where Section 1, or Article 1 comes from, and that's what it would do. Article 2, real briefly, would also expand the criminal abuse of a vulnerable adult to a caregiver that would administer intentionally a controlled substance to a person under a guardianship. And so, Mr. Chair, members, that just expands the current statute we have that already lists several things that are a criminal offense for somebody to take advantage of a vulnerable adult. And so, Mr. Chair, in the interest of time, I know time is short, I'd like you to hear from the testifiers instead of myself. I'm happy to answer any questions, but I'd turn it over to Ms. Joyce Lacey to begin.
Senator Westrom, before we go any further, you have an author's amendment that recognized the intentional administration of a controlled substance to a vulnerable adult without a valid prescription.
That's correct, Mr. Chair. Council has talked to me about this, so I don't know if you want to move the bill to have it in front of you and then do the amendment to get it in the shape.
Why don't we consider the author's amendment, the A1 amendment? Members, I think you have it in front of you. It is a author's amendment. Senator Anderson moves the author's amendment. All those in favor say aye. Aye. Opposed? The amendment is adopted. Is that sufficient explanation, Senator Westrom, of that A1 amendment?
That is, Mr. Chair, as I understand it, working with staff, it was just a better way to word it. Or
I believe it also says it administers the controlled substance in a manner inconsistent with the terms of a valid prescription.
Correct.
That was in addition to administering a controlled substance to a vulnerable adult without a prescription. All right, let's move on to our testifiers. Ms. Lacey, welcome to the committee. Would you first give us your name and then tell us your story?
Thank you. My name is Joyce Lacey, and my mother, June Lacey, was forced into a guardianship back in 2018, in September of 2018. I took her to the ER, and now I'm just going to give you a picture of what she looked like. This is what she looked like before. She was energetic. She was volunteering every day of her life. In fact, we had just volunteered for the Alzheimer's walk, and she had congestive heart failure. She was 89 years old, so I took her in because her breathing got bad. They wanted to keep her in the hospital, and I wanted the best for her, so I said, sure, that if you think that's the best. Well, immediately they started lying. I read through the papers afterwards. They noted her as a vulnerable adult right off the bat, and they could see dollar signs right off the bat. And they changed stories. For example, she was supposed to make an appearance that day, so they said it would be a while before they could get a bed. So I said, can I just drive over and let them know that she won't be able to make the appearance? I came back and I found out later that the person doing the drugs had come in, and she had said, I didn't know what time she was administered this drug or that drug, which I called her about later, and she said, well, you'll just have to call and correct that. And I said, well, why didn't you just say, like the doctor, that I wasn't present? And it made it look like I was a nitwit. Then they asked me, they said, the next day they approached me, they said, can you please put your mother, DNR, do not resuscitate, dump her in a nursing home and put her on hospice. I said, absolutely not. And they tried for 27 minutes to convince me to do that. And so I said, absolutely, I can't do that. So the doctor shook his finger at me and he said, you're a very, very poor power of attorney. Oh, by the way, are you the legal guardian? So right then they're thinking dollar signs. And I said, no, she's not incompetent. She doesn't need a legal guardian. Well, 2 days later when she was getting, basically she was released from the hospital, I handed this piece of paper and she now is in a legal guardianship. I no longer have any control. The legal guardian is her voice. She no longer has any voice either. Well, my mother right away said, no, I don't want to go to a nursing home. And so they came and they gave her a shot. I said, what are you doing? We're giving her morphine. I said, what? She doesn't need morphine. And they said, the legal guardian said to use any and all means to make her comply. And they had her going 215 miles to a nursing home, 215 miles away, which was crazy. We were in the Twin Cities, and there was tons of nursing homes. I called, Good Samaritan had a bed, but no. I found out later that nursing home was operated by the Guardian's company. And so here she was carted off. She was not allowed a phone. She wasn't allowed to even sit on a toilet. She had to use a bedpan her entire stay. She was a prisoner. They were drugging her constantly. Basically, they were hoping, I guess, that her muscles would go into atrophy. And so then what happened was basically that after 3 weeks of being there and treated like horrible, not being allowed a phone, not being allowed to sit on the toilet, being drugged constantly. Anyway, she came down with pneumonia, staph infection, septic blood, UTI, bed sores, temperature of 102. She was really going downhill fast. So, and I begged them, I said, can she see a doctor? And so finally then, the night nurse took her and called 911, and the ambulance came and took her in. Well, they took her in on Monday, and she ended up going to Fargo. And they were wonderful there. They basically gave her 4 IV antibiotics, and she was a fighter. She was 100% Norwegian. If you've seen the Golden Girls, I'm kind of like Dorothy, and she was like Sophia. But so she was a fighter, and she really wanted to live. And so on Wednesday, she was doing good. She was so happy she could sit up and she could eat. They had good food because they'd been giving her day-old pureed food at the nursing home. And so I found a nursing home just real close, Bethany, just 2 miles from the hospital. And I presented that to the guardian, and the guardian's absolutely not. She's going right back 80 miles to this nursing home. And so she was forced to sit in a wheelchair after nearly dying on Monday, being on a ventilator, after 4 IV antibiotics, forced to go back there. And I said, well, at least when she gets back there, then please allow her at least to be able to sit on a toilet or commode, and don't make her use a bedpan, or she's sure to get a UTI or something. And the guardian said, okay, I'll try to do that. Well, she got back. No, she was right back to the bedpan, drugging her constantly with, they call them chemical restraints. And I'm sure you can see the pictures that we've sent in this. There's pictures of what people have been abused. They're black and blue. They're not supposed to use physical restraints, so they use chemical restraints. And as you know, most of the nursing homes are way understaffed. She should have been allowed to go to her home with, 24/7 home health care if it had to be. But anyway, so when she got back there, the nursing home doctor put her on hospice. Well, the rest is history. She was drugged to death. Basically, she couldn't breathe. She couldn't swallow. They were giving her oxycodone and morphine. She had irregular heartbeat. Not only irregular heartbeat, but she had seizures, extreme constipation. She couldn't go to the bathroom for like 3 weeks. And then it was rocks that they had to dig out. It was just unbelievable and unbearable, the hell and torture they put her through. And all the while, I didn't even know there was a Bill of Rights. I didn't find out until a year later. But they violated every single one of those things on the Bill of Rights. Anyway, I started a foundation in her name to try to help other vulnerable adults and children. Yes, it's children also that they're treating like this. And 9 out of 10 of the people that I talked to said that they were not even aware there was a Bill of Rights. When I read them what the rights were, they said they violated every single one of those rights. And so it's kind of like, I need you to act on this today because, for example, if you have speed signs, like it's 30 miles an hour here, 60, if you don't have anybody forcing that, do you think people would go the speed limit? Absolutely not. Well, some people would if they're law-abiding citizens, but others probably wouldn't. And so you need to have this amendment, this bill to enforce that Bill of Rights because they're not paying attention to it. And basically, a guardian can put a person in hospice. My mother wasn't terminally ill. She should have never been in hospice. She had congestive heart failure, and people live with that every single day. So are you going to put everybody with congestive heart failure on hospice? Absolutely not. And if it did anything, it made her heart failure worse and ultimately killed her. And so I'm pleading with you to please, first of all, people should not be put in probate court. Probate court is for property. People are made to be property, and that is modern day slavery. That is wrong from the very beginning. When we were trying to write this bill, we were told, well, we'll never get the people out of probate court. Well, I'm praying that we do. I'm just going to add that the 14th Amendment states that states cannot make laws that violate the privileges and immunities of U.S. citizens that provided under the sovereign federal laws. Unalienable rights are inherent to being human and exist forever outside the world of commerce. They can't be bought, sold, and transferred ever. And governments are instituted to protect and secure our rights. Depriving humans of rights under the color of law violates 18 U.S.C. 241 and 242, carrying criminal penalties of life imprisonment and the death sentence. And I'm just asking you, if this were to go as far as the Nuremberg trials like it did for Nazi Germany, those people that are legislatures that aren't instituting protections for these people, they are responsible. So please, at least act upon this. Have some penalties for these people so that they will be a little bit deterrent. Of course, $3,000 in a year in jail is nothing for actually taking somebody's life and causing harm to a human being. So I'm begging you, please, please act on this today. And you'll be hearing from another person that's testifying. She was fortunate to get out of the country. She had dual citizenship. So she basically, she'll tell her story, but she took her mother and went to Greece. Her mother's alive. It's 5 years later. They gave her mother, same as my mother, just a couple months to live, which they successfully, did away with my mother in just a couple months. Yes, you're talking somebody that looks like this, and there's a picture in here of her in her casket. So it's wrong. It's so wrong. But if I had had dual citizenship, it's crazy that you have to flee America, land of the free, and go to another country to save your loved one. And her mother's still alive. It's 5 years later, and my mother, I believe, would be too. So I'm begging you, please act on this. And if you can make the penalties stronger, I think that would be encouraged, if possible. But we're just hoping to get something on there because, like I said, with the speed limit signs, if you don't have somebody enforcing it, nobody's going to obey those laws. So thank you so very much. Really appreciate your time.
Thank you, Ms. Lacey. Before we go on to the next testifier, I just wanted to inform you, we are not voting on this bill today. We'll be laying it over. It does not mean we are denying the bill. It just means that we're moving it on for further discussion. So I just wanted to point that out to you because you were insistent on wanting a vote today. We'll move on to Joanne Begalis. She's remote, or attending remotely with us. Ms. Begalis, would you identify yourself for the record and then please proceed with your testimony? Apparently, she's not coming online. Is your microphone turned on and is your camera video turned on? Ms. Begalis, we'll ask again if you're on.
There we go.
And can you see me now?
All right, we can hear you. We can't see you yet. Perhaps your video camera is not clicked on. Now we see you and we hear you. Would you identify yourself for the record and then proceed with your testimony?
Yes, thank you, Mr. Chair, members, and Senator Westrom for the opportunity to speak. I'm Joanne Begalis. I'm the daughter of Catherine Begalis, a ward in the state of Minnesota. I've been living in Greece since July 2016. My mother, Catherine Begalis, was labeled incapacitated and was appointed a guardian in December of 2014. And during the following year and a half, she suffered abuses that are now commonplace for wards in Minnesota and throughout the United States. My mother's diagnosis was mild cognitive impairment. But as justification to legally incapacitate her, her diagnosis was abruptly changed to severe dementia. She was then removed from her home and placed into a locked institution where she was forced to take a combination of medication whose synergistic effect is unknown. She was also forced to wear a body monitor to prevent her escape. My mother's diagnosis of dementia was made by a family practice physician with a specialty in obstetrics. My and my mother's efforts for further testing of her cognitive status were denied based on the guardian's claim that such testing would be burdensome for the ward. My mother was desperately unhappy at the facility where she was forced to live, which the guardian agreed was a difficult setting for her because of her high cognitive functioning. The obstetrics physician said that there was no need for further testing. In her opinion, dementia was worse. Incidentally, at this time, my mother was a widow with an estate value at $6 million.
Ms. Begalis, could I interrupt just briefly? Are you reading off of the testimony that you've sent to our office?
Yes, would you like me to just tell you?
I just want to let you know we're having an in and out audio disruption on you giving testimony.
Okay. This is possibly a little better. Does that sound better, sir?
Yeah, it does. But I'll make reference to our members to follow along with her testimony that's in our packets. And then we can continue. Go ahead, please.
Okay. I might have to hold my phone a bit different then.
Well, we can hear you fine now.
Okay. So as I attempted to advocate for my mother, as she and I tried to get help through the court, we found that the system seemed to be set up in a way to silence us completely. My mother was prevented the right to defend herself at the hearing for permanent guardianship, and the emergency guardian forced her to go to routine medical appointment with the same doctor that diagnosed her with dementia at the exact hour of the hearing. Are you able to hear me okay now?
Yes.
Okay. At subsequent hearings, she was denied the opportunity to testify, as by then she was already labeled legally incapacitated. When I spoke on her behalf, I was accused of being unwilling to work with the professionals. When I continued advocating for her rights, I was threatened by the guardian that I would never see my mother again. After 18 months of my mother begging for her freedom, having no success being heard or getting justice through the probate court, nor any help from 20 agencies that we reached out to, we finally gave up on utilizing the expected channels. In May of 2016, my mother managed to physically escape her institutional setting and succeeded in removing her electronic body monitor. Because she's fortunate to have dual citizenship, my mother sought and was able to obtain assistance from the Greek embassy. So she and I were provided emergency passports, and which allowed us to escape to Greece. In Greece, almost 2 years after her diagnosis of severe dementia by a family practitioner specializing in obstetrics, both a neurologist and a psychiatrist diagnosed my mother with mild cognitive impairment, her original diagnosis. Off the medication she had been forced to take in the facility and free of confinement, her functioning improved significantly. While the guardian had claimed it was not in my mother's best interest to travel or to be with her family, she adjusted well, even though she had not lived in Greece for 50 years. She reconnected with extended family and old friends and has lived successfully in her community as a free citizen for the past 6 years. My mother's guardianship is still active in Minnesota, and her guardian continues to get paid. Despite the fact that the court and the guardian have been given legal notice of my mother living in Greece, the guardian continues to report her whereabouts as unknown, and the court continues to accept the reports. The guardian continues to collect her teachers and nursing pensions, while my mother receives no financial support whatsoever from her estate. Her estate is now reported by the guardian to the court and to the family on an annual basis to be worth $600,000, a mere 10% of its original value. When my mother and I attempted to participate in a Zoom hearing in 2020, the judge denied us access until after he approved the financial documents submitted by the guardian. Although the court previously denied her right to hire an attorney, the judge informed me and my mother that if we did not agree with his decision, she could hire an attorney. I too was unable to hire an attorney because of the warrant against me submitted by the guardian and accepted by the judge. We were good citizens and contributing members of society. My father was an immigrant and a successful businessman. I served in the U.S. Marine Corps and in the U.S. Army, and I'm now a disabled veteran. My immigrant mother, worked in the helping professions as both a teacher and a nurse. She's not been able to find justice in Minnesota or in the United States, and instead had to seek help from Greece, her country of origin. My mother cannot return to the U.S. without being forced and isolated into an institution. I cannot return to the country I serve to protect because of the warrant for my arrest for accompanying my mother to freedom. My mother's and my experience suggest that there's a serious problem with how guardianship and probate courts operate in Minnesota. I'm aware there's a Bill of Rights for Minnesota wards. However, in our experience, these rights are not enforced, not even by the probate judges, who seem inevitably to refer to the guardian's wishes. Beyond the need to overhaul the entire guardianship system to protect future victims, there is an immediate need for accountability and for actual penalties when guardians violate wards' rights. Considering the well-known research of Stanford University psychologists Philip Zimbardo and Stanley Milgram on abuses of authority in settings of extreme disparity of power, it's clear that a setup such as guardianship that permanently strips rights from one person while giving virtual absolute power to another is a recipe for exploitation and abuse. Based on the research, from a scientific perspective, the maltreatment of my mother by her guardian is an expected outcome. So it's no surprise the day that the guardian got appointed, he said to my brother and I am now your mother. For detailed information on my mother's story, please visit our website by searching Begalis Guardianship. And I want to thank you in advance for supporting the changes in the law that will address these issues. Thank you.
Thank you, Ms. Begalis. We also have an individual in the audience, Kathy Cooper. Please come up to the table.
Mr. Chair, I'll step aside.
And Ms. Cooper, once you get settled, why don't you introduce yourself and then proceed with your testimony.
Yes, my name is Kathy Cooper, and I am also disabled. I was surprised to hear Joanne's testimony. I've never heard it before, so I know very few people that have gone through the trauma of guardianship twice. My mother, who was a school teacher, was put into an abusive for-profit court-appointed guardianship. She too had just very mild dementia. And all of my mother's rights were violated by her guardian. The worst, I believe, is the Bill of Rights in number 10, the right to communicate with persons of her choice. And also the other right that was worst for my mother was the right to timely and appropriate medical care. My mother had a brain tumor a couple years before she was put into the guardianship, and she needed to have the brain tumor originated in her hearing, both sides of her ears. She had to go to her surgeon every 3 months to have him clean out her ears with an operating microscope, or she could not hear. When my mom was in guardianship, I made an appointment for my mom to see her surgeon. I petitioned the courts to allow me to take her to the probate judge refused to hear my petition. The guardian canceled her appointment, and my mother was totally deaf for the last 5 years of her life. And then when you couple that with being isolated from the people that she loves, that's horrible abuse beyond compare. And but I'm not. My mother was murdered by her court-appointed abusive guardian on May 6, 2015. And I'm here because my husband, who is totally competent, 100% competent, is in an abusive for-profit court-appointed guardianship. My husband, Irvin Cooper, used to be an engineer at 3M, and they're obviously after his money. They've been violating all of his rights as a ward, and so again, the isolation is the worst one. And in both times with my mother and in the past year, the favorite tool of a guardian is to put a harassment restraining order against the person trying to help the person under guardianship. So my mom's guardian put a 3-year harassment restraining order against me, and I didn't think my mom would live 3 years, so I brought it up to the appeals court where I did not prevail, but it's extremely expensive to do that. Even after my 3-year harassment restraining order was up, the guardian would not allow me to see my mother. So they're doing the same thing with my husband's situation, guardianship. He's had 2, in the past year, he's had 2 emergency guardians. The first one was by his son. I was in the hospital with COVID and his son kidnapped Irvin and put a harassment restraining order against me, preventing me from helping Irvin at his hearing on August 25th. Irvin was so frightened of what would happen at the hearing that he agreed to a stipulated conservatorship and for 1 year. And then on October 7th, when he was a free man, not under guardianship, just under conservatorship, they put him in ex parte guardianship, ex parte emergency guardianship. And they tried to find him. He was successful at hiding from them until he broke his hip in December, and the guardian found him in the hospital. Actually, somebody betrayed Irvin. So he's been under the guardianship's clutches since then, and he does not have access to a phone. He cannot call anybody. He didn't have access to the phone at Mercy Hospital. He did not have access to the phone at Unity Hospital, and he does not have access to a phone right now. He's at Brightondale Assisted Living in New Brighton, and he does not have access to a telephone. That's a violation of state and federal laws. And I can go on and on and on, but I know the time is limited, and I'm just praying that you senators would do the right thing and vote for this bill. Thank you.
Thank you, Ms. Cooper. Is there anyone else in the audience who wishes to speak for or against this bill? Hearing none, we'll move on to committee
May I just
discussion.
add, I was told I was supposed to be limited, but I did
Ms.
want to
Lacey.
also mention that I was threatened with arrest if I took my mother outside the door, and again, she wasn't allowed a phone, same type of thing. It's isolation medication. That's like typical guardian, and it's really sad. And when I refused to have her go back to that nursing home 80 miles back, first of all, the trip could have killed her, and we had a place just 2 miles from the hospital in Fargo. I was basically removed by security from the hospital like I was a criminal trying to advocate for my mother. And then when she got back there, I was only allowed 2-hour supervised visits Monday through Friday. So again, it's just terrible what they put these people through, isolation and medication. And this is before COVID. So again, please act on this. Please do the right thing. I hope you look through the rest of the testimonies.
I forgot to mention one really important thing, if I can
Ms. Cooper.
interject. Thank you. My husband's guardian came on October 15th to my home, my husband has a home in White Bear Lake. He was locked out of his home and his yard by his guardian. So not allowed to go into the home or the yard so my husband was living with me, and I'm in the Safe at Home Address Confidentiality Program. And the guardian violated Safe at Home laws, violated my police-issued no trespassing signs. He came and took both of our vehicles on October 15th. My wheelchair was in the vehicle, my trekking poles. I am severely disabled, and he took our vehicle, stole our vehicles. And I'm driving a smashed up car now, and the police just gave a citation to me, my vehicle in the driveway that only has one headlight. and they gave me a junk vehicle citation. This is all harassment. This is severe harassment and violation of the law. The guardian, in the judge's order, he said that he could use the police in any means possible. He also used my county workers to try to serve me with the harassment restraining order at my house. They're supposed to serve me at Safe at Home through the Secretary of State's office. I've been experiencing extreme harassment from the guardian, and they would not allow, I tried to get a harassment restraining order against the guardian, and they would not give me one, where he's got a fraudulent one against me. This is just not right, and it's not fair. Thank you.
Thank you. We'll move on to committee discussion. Senator Giffmeyer.
Thank you, Mr. Chair. These are grievous stories and a grievous violation of an individual's rights, clearly in statute 524-5, Bill of Rights for persons subject to guardianship or conservatorship. Clearly, these are absolute violations. And when I take a look at this statute, there is no consequence for this crime. And it is a crime to deprive people of these basic rights, human rights. A number of these, the right to have an attorney, just numerous rights that are included here. But without this consequence, people like this are stuck in a court system. The one thing, Mr. Chair, I'm really amazed at here, it's one thing for the guardians to be doing this. It is another thing for the court sanctioning these activities when the courts clearly have a responsibility to enforce the rights of the ward. Those are clear rights. It's really sad. I know that many guardians do a good job. We appreciate that. But when they go off and are not right, these are extreme abuses that greatly affect the individual person and their family members. And this can be both personal to their person, but also to their finances. And without any consequence, such as what we don't appear to have in statute at this time, I think it is really imperative that we do create this criminal penalty for an abuse of these rights. Because if you don't have a penalty, you don't have the tools that are needed here. But the other thing is, I would really appreciate, Mr. Chair, at some time in the future that the courts have a responsibility here to answer to this situation. But what we're on right now is this criminal penalty, and I think it is really, really imperative, Mr. Chair, that we do this and want to speak very strongly for it. Thank you, Mr. Chair.
Thank you. We'll move on to Senator Matthews.
Thank you, Mr. Chair. I want to say thank you to you two ladies sitting at the table for sharing your stories. And thank you to Ms. Begalis online for sharing your story as well. These are very grievous stories to hear. And Mr. Chair and members, we need to call this what it is. This is medical tyranny. And this happened even a few years ago, where probably before the last few years, this might not have been on many people's minds. It might have been left out in, might I say, fringe elements where it affected a few people, but not many people in the general public are aware of it. Now, after the last couple of years, just about everyone in the country, if they're willing to be honest, knows that big government and big medicine can band together in a way to exercise medical tyranny over just about anyone they choose to. And I think we can get the public on our side with this. Guardianship law falls under the civil law jurisdiction that I'm the chair of. And another member on that committee is you, Senator Westrom. And I think we need to take a look at this. I'm reading the language in your bill and your amendment here. And this is stated for, this seems to be pretty broad language stating it's a crime for essentially any legal guardian as it's read. And I wonder if we need to tighten that up and focus on professional guardians, perhaps. And I know that you're a member of the committee, that you're passionate about it. I've been passionate about multiple different forms of medical tyranny, especially in the last couple of years. And I think this needs to get added to the list. This absolutely has no place in a country that has the freedoms under the Constitution like we do in the United States of America. And so I'm not yet sure if the language in this bill says what we want it to say at the end. There absolutely needs to be some kind of penalty, some kind of repercussion. It needs to be focused in specifically on those that are out intentionally committing wrongdoing and committing, let's call a spade a spade, committing evil actions against people like this. And Senator Westrom, I hope that you'll continue working with me on this. I think we need to step back and take a larger view at this professional guardianship issue. And since you have a front row seat to the committee that has jurisdiction over it, I welcome the opportunity to work with you on that.
Any further discussion? Senator Latz.
Mr. Chairman, thank you, and thank you to the testifiers for sharing your stories. They're heart-wrenching and hard to believe that they happen today in our American society. I'm not as familiar as I guess I would like to be with the guardianship system, although I've come across it on a number of occasions in my private practice and, of course, through our work here. There is a board that monitors, regulates, licenses professional guardians in Minnesota. And there are lawyers that specialize in lawsuits against nursing homes for abuse. I'm just wondering if any of those options have been investigated, taken advantage of, considered, whether there have been any complaints to the guardianship board, concerned about whether or not the courts have adequate resources to be able to meaningfully oversee guardians within the probate system, or whether there are other resources or tools that might be brought to bear to make sure that the courts are fully aware of what's going on before making decisions as well. So I don't think it detracts at all from the bill that's before us, the proposal that's before us. But there are some other options here that we might want to get some information on.
May I just add that I
Ms. Lacy?
called Adult Protection Services 4 times when my mother was in that. Mind you, she had pneumonia, staph infection, septic blood, UTI bed sores. 4 letters I got back, they decided not to investigate. The people that are supposed to be doing these types of things are not following up with what they're supposed to do. I called the ombudsman for the nursing home, refused to investigate. They don't want to get involved. I finally called the police officer in that city. The police officer came forward. He came, and the head nurse at the nursing home was ready to just shoot me. And he came in and he said he wished he could do more, but he couldn't because she's in a guardianship. But he said, I can tell you this, if she were a convicted criminal, she would have more rights than she does as a ward of the state. And that's really sad because she could say, I don't want those meds, they're making me sick. I want a phone. But basically, they're prisoners. And I think that's pretty obvious in, the testimonies and the ones that you have before you too. So just wanted to let you know that those things that are out there that are supposed to protect them are not doing it. Adult protection is not doing it. Being denied 4 different letters, and I have those, that they decided not to investigate. How do you decide not to investigate somebody who's got pneumonia, staph infection, septic blood, UTI, bed sores, temperature of 102, and I'm sorry, black and blue? It doesn't make any sense. So I know it's meaning, but we really need to do something because there's people dying every day. So.
Thank you, Senator Latz. Senator Pappas?
Thank you, Mr. Chairman, and thank you so much for the testimony. I'm just realizing that I think I dodged a bullet with my own mother, who was also diagnosed with mild cognitive disorder. I got the power of attorney early on, and maybe that was helpful, but I don't even understand why there would be a guardian appointed if there were family members that were willing to provide that kind of support. I did have one experience where she was put in a nursing home. I don't remember, maybe UTI or something. And the doctor that was evaluating her told me that she failed the toaster test, so she needed to stay in the facility. And we were prepared to take her back home. And I said, no, it's because it's not her own toaster. No, it's just the familiarity of things in your own experiences, or she may have felt stress or whatever, and she was just recovering from an illness too. And so when I insisted on her going back home, he literally reported me to Hennepin County. And I said, what do I have to do to comply? 24-hour care. And so we arranged with an agency to provide 24-hour care, and the county was happy with that. And then gradually, we reduced the care because she didn't need it. She used her long-term care insurance for, 2, 3, 4 hours a day, plus family members helping out. When she finally went into a facility, I found the most amazing facilities that did not believe in over-medicating, thank God, and took excellent care of her. She never had any kind of bed sores or fever. She never got sick. And she lived for like 13 years. It was sad. Alzheimer's is a sad disease, right? So they do lose their sense of who they are. But we are very thrilled that she, $7,000 a month, used up all her money providing her with the best possible care. So again, I feel like I dodged a bullet here. Thank you so much I'm so sorry for what happened to you.
Any further discussion? Senator Anderson?
Thank you, Mr. Chair. I realize being a guardian for my daughter who has cerebral palsy is a very high position to be in and not to be taken lightly. Ms. Cooper, I don't understand how you weren't allowed to be a guardian for your husband. It totally doesn't make sense, because I know when I was asked to be the guardian for my daughter, that there was really no question. They basically said, you are the father of, and to me, this is totally kind of Twilight Zone to hear that. So do you have any explanation, Ms. Cooper, on what transpired?
I said the explanation, for profit. It's all about his money. These are abusive, for-profit, court-appointed guardianships, 100%.
Mr. Chair,
Senator Anderson.
Ms. Cooper, you had no say at the court hearing when the judge made that decision?
No.
What?
Absolutely. They didn't even
Ms.
allow me as an interested person until February 28th, I believe, the hearing on February 28th. They allowed me to file in as an interested person. Prior to that, they didn't give me standing.
Did they give it,
Senator Anderson.
Mr. Chair, did they give any explanation as to your position or why you couldn't be, or they just flat said no, that you're not eligible?
They wouldn't. My attorney asked at every single hearing to let us file into the case, and he would not until February, I believe it was the 28th of this year.
Mr. Chair, this is
Senator Anderson.
just like Senator Matthews just said. This is tyranny, medical tyranny, and an abuse of the justice system on normal citizens. This has to be stopped. Thank you.
May I just add one thing too?
Yes,
a lot
please.
of times they will just write out lie. For instance, I was going to tell you that basically what they They asked me, they said, well, why don't you want your mother in a nursing home? The nurse asked. And I said, well, I've been in a nursing home. I know what it's like. I think maybe the Lord had me go through this, so I know not to put my mother in a nursing home. You know what she wrote in her report? That the mother was in a transitional care. She'd never been in transitional care at a nursing home, but they lied. They said she'd been in transitional care, and the daughter was so obnoxious that she got her kicked out. They were trying to make me look obnoxious and that I was a horrible person, because I guess they don't like people that are too involved and too much of an advocate for their loved one. So, I mean, they just turn the tables, and basically it's not right, but they do that. And so I don't know if they possibly did the same to her, or they lied about something, but that's how they changed the story. And it wasn't true at all. So, and that was my explanation, and that was the truth. I basically was in a nursing home. I didn't want my mom to have to go through that. So anyway, but unfortunately, they get by with that. So.
Any further discussion? Senator Matthews.
Thank you, Mr. Chair. So question for Senator Westrom, and in thinking and hearing this testimony through, Mr. Chair, I might suggest that when we're done debating this bill, perhaps I will ask, and I'd like Senator Westrom's opinion on this, ask to move the bill to the Civil Law Committee, and we could take a vote on that here today, and then give Senator Westrom and myself and others a chance to keep working on this broader guardianship issue. And I'd like Senator Westrom's insight on how he feels about that.
Senator Matthews, the original intent of our business was to lay it over for further discussion, but your motion is in order. So Senator Westrom.
Mr. Chair, Senator Matthews, I would appreciate that. The stories you hear, and there's many more in the packets. We knew we had time constraint. There is incredible stories and things that need to work out. So I would welcome that, Mr. Chair, if that's something you're comfortable with. Because part of the intention and the reason this hearing is so helpful is I know there's many considerations with guardianship. And so if we can bring parties together, these stories, as I keep talking to people, I find out more and more. It's not like it's a rare situation, and that just pains me. And so I do believe there's more work, but we do need to put some stiffer penalties in place, because at some point that is what makes everybody step back and take their fiduciary obligation and how they handle what they're doing much more carefully, and not be so quick to either dismiss. And as long as they can go home to their family and have supper and relax and be comfortable, that doesn't mean the person under the guardianship is in that situation. And that's what we need to get to, find some, there's a broken system here that needs repair. And so I would welcome that.
Senator Bigham.
Thank you, Mr. Chair, and Senator Matthews, Senator Westrom. I agree. I think taking a look at this in civil laws on this specific issue is very important, and so I would support that recommendation. To the testifiers, thank you for your testimony, and it's just heartbreaking what you and your families have experienced. So thank you for being here today.
Senator Latz.
Mr. Chairman, I think civil law review might be a good thing to do. I'm just wondering, maybe I missed it, but has this bill already met first deadline? If we send it to civil law.
This is the first hearing of this bill. What is our first date? A date for deadline? The first deadline?
Today.
Mr. Chair,
Senator Matthews.
because I'm a policy-only committee, does that, I need to double check on the specific rules. Since this is the Finance Committee component, do we meet deadline by passing it out of this today, just to civil law?
What's the House status?
One moment,
If-
look it up. Senator Latz, it looks like it was referred to the Public Safety and Criminal Justice Reform Finance and Policy Committee in the House. It does not look like they have acted on it. Counsel?
Mr. Chair and members, I think that with the interpretation of the deadline rules, it's kind of strange, but my understanding is in some cases, just by introduction into a committee that is essentially a finance committee, which I believe the House Public Safety Committee is considered a finance committee, I believe they would think that that made first deadline over there. So I think, I'm not positive, but I think that that would not preclude civil law from taking this up next week if they chose. I mean, worst case scenario, it would be considered a late bill and it would then go through rules.
I still believe that the motion is in order. I agree with you, Counsel. The House has different interpretations of what late bills are, and they're a little bit more accommodating than the Senate is. And at the very least, it could be referred to Rules Committee as a late bill, and then they would consider justifying the hearing.
Mr. Chair.
So, Senator Westrom.
Mr. Chair, one of the other things is if one part of the bill is more ready for prime time and another part we need to work on, there's nothing that precludes part of it being added as an amendment, and I would urge you to consider that in your omnibus discussions or your final bill that you put out is another option. I believe that could be a way to keep some of it moving if we're working on other parts of it too, but right. I'd defer to your deference, Mr. Chair.
Well, our discussion gives us a number of avenues to still travel. Senator Latz?
Senator Westrom has an idea there, and plus Senator Matthews was inquiring about the difference between professional guardians and non-professional guardians too, and gives me pause whether we make a non-professional guardian, a family member, a gross misdemeanant if they violate certain provisions here, as opposed to professional guardian, who I would hold to a higher standard in terms of responsibility and knowledge. And so I think that might be worth exploring as well. Maybe this could be dual tracked in the sense that, the bill itself could be sent to civil law, but the intent was to lay it over for possible inclusion in a larger bill here, and that could still happen. The language could still be included in a larger bill here, even if the bill itself travels to a different committee. Effectively dual tracking it as an option and giving civil law an opportunity to take a look at it, and maybe us an opportunity to think about whether we want to create distinctions in the criminal penalties between the different kinds of guardians.
Yep. Senator Giffmeyer, any additional comment?
Thank you, Mr. Chair. I didn't know if it would be helpful at this stage to just do an oral amendment on line 3.4. It is a crime and to insert a professional legal guardian. I know it's moving on to civil law where they may do more. I just was wondering whether that might be helpful and would be fairly quick considering the conversation and the discussion today. If not, I will leave it to civil law.
Sir Giffmeyer, I appreciate the help. I think we're just going to move it to civil law if it's
okay. That's
committee. Senator Latz.
Mr. Chairman, the only hesitation I would have is if the bill as a whole with the two criminal penalties moves on to civil law. Theoretically, it could move from civil law to the floor without us having an opportunity to dig deeper into the content of the criminal consequences here. The one reason I raise that is not only because of the potential bifurcation between the kinds of guardians, but if you look at the Bill of Rights itself, some of those which would become gross misdemeanors to violate are pretty broadly written, non-specific as to the conduct that would be prohibited. I'll give you an example. On line 1.13, it's a right includes to be treated with dignity and respect. So what does that mean in terms of telling someone that they're going to commit a gross misdemeanor crime, could be imprisoned for up to a year in jail if someone asks for a piece of toast and they are told no, they can't have a piece of toast, and then the allegation is, well, that didn't treat me with respect, I wanted the piece of toast. And I'm not trying to make light of the situation, but just to illustrate, I think we could sit here easily and come up with a whole range of conduct that might be interpreted one way or the other. And we could probably read through this also and find an awful lot of, refusal to communicate, personal privacy. I mean, there's a lot of stuff here that is just awfully broadly written that I think we ought to be careful about whether we criminalize some alleged violations of them. And I think this committee needs a broader discussion. I'm not sure you want to take the time to kind of sort through that right now.
No,
Either. And I'd be a little bit reluctant to hand off the ability to pass a bill from civil law onto the floor without having that level of discussion here in the criminal law committee.
Senator Latz, once the Civil Law Committee looks at this bill, and if they want to advance it, then we certainly would reserve the right to have it back in our committee. And we could perhaps have a little more time as we ponder how to write something into this provision. I think that might be just remembering that we have the right to do that.
Mr. Chairman, I don't know if we have the ability to do this. Can we pass it to civil law? And with the caveat that civil law will agree if it's to be passed out of civil law, it gets re-referred back to judiciary for further consideration of the criminal law aspects of it. So there's not a chance that it could be sent directly to the floor.
I'm not quite sure how to put that in a motion, Senator Latz.
Mr. Chair?
Senator Westrom.
Mr. Chair, as the author, I would commit to working with Senator Latz and the committee on some of those issues. So I do see this as a bifurcated process. I think there's Article 2 is probably more ready to move forward with than Article 1. And so, Senator Latz, I really appreciate your thoughts on this. I certainly wouldn't want to have unintended consequences and chill the need for guardians. But there is something out of whack right now, and I think especially in the professional sign of guardians, because that's usually not a family member. It's not somebody that is necessarily connected to the person. So I think you make a reasonable statement. And so as the author, I don't know if there's anybody else that says I'll come back through judiciary, but if that would be comforting and needed, I think that would be proper. And if part of it moves this year and part of it needs more work, that's the benefit of this committee. And I'd welcome anybody in the audience. The Bar Association, I know, has groups that work on this, both sides of this. And so we would welcome, Council on Disabilities and other groups that have talked to us about this. We need to have a stakeholders meeting, I think, and bring some more thought to toughening this up because it something needs to be stiffer. But I think there's more thought that needs to go into parts of it. So that's where I would be at, Senator Latz, if that helps, and Mr. Chairman.
Senator Matthews.
Thank you, Mr. Chair. And as the Chair of Civil Law, I would echo Senator Westrom's comments that I'd be more than willing to take the bill with the understanding of sending it back to Judiciary to consider. And ladies, you're getting to see us debate process and how we fit these puzzle pieces together, as well as the underlying policy. And civil law doesn't have very many meetings left, and we may need to perhaps just take a post-deadline hearing. Maybe we need a broad informational guardianship hearing as a stepping point. So I know I'll be talking with my staff later on, planning out next week's agenda. Don't know where this bill fits in that yet or not, but I know this is a big enough issue that you all have helped shine a light on this, that we do need to take a step back and deal with that. And I'd be yes, with the strong understanding that after we review that portion, it should return back here to Judiciary for the criminal component of it.
Sir Latz?
Mr. Chairman, I think that's a welcome statement and development, and I think it preserves this committee's ability to dive more deeply into the criminal law elements of it. And it would give civil law an opportunity to consider civil cause of action as an enforcement mechanism as well, or maybe in substitution for criminal law consequences. I think there's a lot here. I'm really glad it came forward so we can look at this. We want to make sure what we do is going to be effective in accomplishing the goals here, and we do it the right way.
So Senator Matthews moves that Senate File 1462 as amended be recommended to pass and be moved to the Civil Law Committee.
That's correct, Mr. Chair.
Senator Latz?
Mr.
Discussion
Chairman,
on the motion.
Yeah, I would ask the chair, Senator Matthews, to consider that it be moved without recommendation at this point.
Okay.
All right. Senator Matthews amends his motion to read that Senator Matthews moves Senate File 1462 as amended with no recommendation be sent to the Civil Law Committee. Having no other discussion, all those in favor say aye. Aye. Opposed?
Aye.
The motion prevails.
Thank you, Mr. Chair and committee members.
We'll now move on to Senate File 3175, Senator Bigham.
Joyce.
Thank you all for coming.
Thank you, Mr. Chair. Thank you. Thank you, committee.
Senator Bigham.
Thank you, Mr. Chair. I appreciate you and the committee's time in consideration of Senate File 3175. Just for the record, the House has passed this and it's on the General Register, just for organizational purposes. Senate File 3175 is a congressional resolution.
Proceed, Senator Bigham.
Thank you. Is a congressional resolution to support changing, to name the South St. Paul Post Office in honor of Officer Leo Pavlak. In your committee packets, there is a letter from Officer Pavlak's grandchildren, and it's just a couple paragraphs. So I just want to quick read it. It's addressed to me. We write in support of Senate File 3175, a resolution seeking congressional support to name the South St. Paul Post Office in honor of Officer Leo Pavlak. Officer Pavlak, age 38, was killed in the line of duty in August of 1933 during a payroll robbery in South St. Paul. Having the post office named in his honor is a true and fitting memorial. In addition, it has great meaning to all of law enforcement officers, but particularly those who are his decedents. Leo has had a significant, long-lasting effect on policing, especially in our family. His son, Robert Leo Pavlak Sr., retired from the St. Paul Police Department as a lieutenant and served as the U.S. Marshal for Minnesota. Some of Leo's grandchildren and great-grandchildren have become police officers and continued the tradition of service to the community. Thank you for supporting the resolution to name South St. Paul's Post Office. Sincerely, Leo's grandchildren, Catherine, Mary, Susan, Robert, David, and Rurik. Mr. Chair, on the Zoom is South St. Paul Police Chief Bill Meserick, and before I turn it over to him, just want to thank him. Mr. Chair, he's retiring, and he's had decades of experience in law enforcement in South St. Paul. Been a tremendous partner to me over my career in various policies, but just an overall wonderful guy who is a shining example of law enforcement. So one, I want to congratulate him on his retirement, thank him for his dedicated service to South St. Paul, but also surrounding communities. And I know this is a very important issue for him and his department. So with that, I will turn it over to Chief Bill Mesrick.
Chief Mesrick, welcome to the committee. Would you introduce yourself again and then proceed with your testimony?
Thank you, Mr. Chair, and thank you, Senator Bigham, for those kind words. On behalf of the City of South St. Paul, its police department, and the family of Leo Pavlak, I want to thank the committee and particularly Senator Bigham for considering this resolution of support honoring Officer Leo Pavlak. While this bill would help out recognize officers' sacrifice while in line of duty on August 30th, 1933, I do want to overemphasize the importance of and note his family legacy. As Senator Bigham noted, his son worked for the St. Paul Police Department and the U.S. Marshal's Office. Two of his grandsons were in law enforcement. One worked for the Ramsey County Sheriff's Office and one for the St. Paul Police Department. And currently, his great-grandson, Ryan Pavlak, is a community service officer with our police department, and he is on our list to hire as an officer as soon as he finishes school, hopefully this year, and hopefully he can become a police officer with the City of South St. Paul. So with that, I guess we feel that this recognition of his sacrifice is about 88 years overdue, and we thank you for your support of Senate File 3175.
Thank you, Chief. Is there any other testimony, Senator?
No, Mr. Chair, not that I'm aware of.
Anyone in the audience who wishes to speak for or against this bill? Hearing none, we'll move it to committee discussion. Senator Pappas. Oh, no.
Mr. Chairman, we should also mention that his son, Bob Pavlak, served in the Minnesota legislature in the 60s and the 70s.
Thank you, Senator.
I thought that name sounded familiar, so I had to go look it up.
So the family's been involved in service to their community through multiple generations. It's important to realize that. Not everyone wants to be a police officer.
Right.
But they can serve in other ways.
Right. Absolutely.
Any discussion by the committee? Hearing none? Senator?
Thank you, Mr. Chair. With that, I move that Senate File 3175 be recommended to pass and sent to general orders.
Senator Bigham moves Senate File 3175 be recommended to pass and be sent to the Senate floor. All those in favor say aye.
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 Opposed? The motion prevails. Thank you, Senator
Thank you, committee.
Bigham.
Mr. Chair.
Senator Lang. Senator Lang has Senate File 724. He and his testifiers are coming to the table. This bill was heard in civil law not too long ago, and it was re-referred to our committee.
Well, good afternoon, Mr. Chair, members.
Senator Lang.
Thank you for the invite and the willingness to hear Senate File 724. 724 has been a bill that both the department has brought to the Veterans Committee last year and has been realistically going through quite the process as it's been progressing. The idea or the thought process behind 724 is to align Minnesota Code of Military Justice to align with the federal version of the Universal Code of Military Justice. There's many sections to it, and I can tell you that as not being a lawyer that I'm definitely not the expert on most of those sections. And so for that testimony today, we have both Lieutenant Colonel Blomgren to my right and Mr. Don Kerr to the left. So with that, Mr. Chair.
Before we continue, Counsel, could you tell us what our jurisdiction is in this bill?
Mr. Chair, members, I think the committee's jurisdiction is basically Articles 3 to 6.
3 to 6. So, instructions to your testifiers, if you give us just a brief overview and then focus on Articles 3 through 6 would be our focus for today. Who would like to begin? Would you introduce yourself and then proceed with your testimony.
Thank you, Mr. Chair and members of the committee for hearing the bill today. My name is Don Kerr. I'm the Executive Director of the Minnesota Department of Military Affairs. And as the author stated, we go through an ongoing process to update the Minnesota Code of Military Justice to be in alignment as much as possible with the Uniform Code of Military Justice on the federal side to facilitate the ease of use and the consistency for our service members when they're serving in Title 10 on federal active service and when they're serving in Title 32 to the state. And this is, the last time we did this, I think it was in 2014. And we're already seeing some changes in the UCMJ come out that will probably require us to be back here again in a couple of years, but we think this will get us for a little bit. But some very significant changes here that I'll let Lieutenant Colonel Blomgren talk about. He is the staff judge advocate for the Minnesota National Guard. In the interest of time, Mr. Chair, I'll constrain my comments to that and stand for any questions if necessary.
All right. Thank you, Director Kerr. Our other testifier, would you identify yourself for the record and then proceed?
Thank you, Mr. Chair. Committee members, for the record, I am Lieutenant Colonel David Blomgren and serve as the General Counsel for the Minnesota National Guard and Department of Military Affairs, where I serve as a full-time legal advisor to the Adjutant General and other senior members of the organization. I assumed this duty in 2018 after serving 11 years on active duty in the Air Force. First, let me thank you for inviting me to testify this morning in support of this bill. Compared to the active duty force, our military justice structure is quite different, given the fact that most of our members are not on a duty status most days of the month. While we currently have the legal ability on paper to conduct a court-martial, there are gaps that would make it legally impractical to conduct one now. This bill will fill those gaps and in turn will provide that additional legal tool in the commander's toolbox to ensure good order and discipline in the Minnesota National Guard. So I'll identify a few of those gaps briefly. The first gap is the legal authority to receive law enforcement data on Minnesota National Guard members when they're investigated by local law enforcement. In many cases, local law enforcement, when they investigate and their prosecutor in that county determines that there's not enough evidence to pursue a criminal charge, we have the ability to pursue administrative action or consider a court-martial. 9 times out of 10, the local jurisdiction provides us the necessary investigation so that we can take action. However, some jurisdictions currently do not. And that simply adds to the time that it takes to investigate wrongdoings, since we must then do our own investigation. And that is particular when it comes to investigations of sexual assault. This bill would authorize the Adjutant General to receive, via request from my office, law enforcement data of members in our organization for the sole purpose of taking administrative or criminal action. Another gap of experience is the ability of out-of-state attorneys to provide military legal advice without having to go through the pro hoc vice process. And this bill would allow out-of-state licensed attorneys to provide military defense services or to serve as military judges, provided they are otherwise qualified for such duty by the Judge Advocate General of their service and are a member of another state's bar. This is consistent with how the JAG Corps operates on the federal level. And while we are typically able to utilize Minnesota licensed attorneys, there are times when we need to go out of state, particularly when senior members are being investigated. This change has been socialized with the Minnesota Office of Lawyer Registration and Office of Professional Responsibility, and they concur with these changes. This bill also fills a number of jurisdictional gaps or ambiguities that currently exist on paper. Specifically, it clarifies when members are subject to the Minnesota Code of Military Justice. It clarifies which crimes are considered military-specific crimes and therefore give us primary jurisdiction. And finally, it clarifies some of the maximum punishments for the punitive articles of the code. The fourth gap that this bill fills is the appellate process for court-martial. Currently, it's unclear how a defendant or the government would appeal a court-martial, and this proposed change would clarify when the appeal period starts to run and clarifies the appellate authority as the Minnesota Supreme Court. These changes have also been reviewed and concurred by the Minnesota Attorney General's Appellate Division. And finally, this bill aligns the Minnesota Code of Military Justice with updates to the Federal Uniform Code of Military Justice with respect to newly added punitive articles. Again, I thank you for your time this morning to testify, and I'm happy to answer any questions you may have.
Anyone in the audience who wishes to speak for or against this bill? Hearing none, we'll open it up for committee discussion. Any questions? comments? Senator Giffmeyer?
Yeah, thank you, Mr. Chair. I think I just wanted to take a look at in Article 4 on page 4, having to do with rulemaking. And so this brings up a flag for me as Chair of State Gov with oversight and responsibility on rulemaking. So I'm quickly looking at this to be sure that this may need to go to State Gov because of rulemaking. I'm reading in this regard, it is current law that they can do this by rules. So maybe I could ask the question right now, what levels of rules, what sections of rules, what rule pages or numbers or section of the rules is currently being used, if any, if the testifier could respond to that.
Senator, Mr.
Please
Chair.
go
Yeah, so currently, it should be noted that we haven't done a court-martial since the 1920s, so there's no current practice. Right now, the current statute allows for the rules to follow the state criminal process. This would change it to allow the governor to prescribe the manuals for courts-martial. So the manual for courts-martial has the military rules of evidence, and so that's what we have been trained as military attorneys on, are those rules. And so we did route this question up to the Commissioner of the Supreme Court to determine whether or not, if this law changed to the rules that we would follow would be the military rules of evidence, if that would be an issue, and they said that it would not. It would be similar to kind of the bankruptcy court, how they operate. As long as there are rules that we need to follow, the Supreme Court can certainly determine whether or not we followed our own rules. So this makes it certainly simpler because our military attorneys and military judges are trained in the military rules of evidence as opposed to the state criminal rules of evidence.
Senator Giffmeyer.
Yeah, thank you very much, Mr. Chair. That is very helpful. In general, we deal with rulemaking that is done by agencies. So this stands out where the governor may prescribe rules. But I understand now as the commander-in-chief over some of the military areas, especially National Guard, that would kind of come through that process. I think as I see this, I don't think this needs to come to State Gov. This is a different kind of situation of rules. And I think your explanation has been helpful. So I won't pull this bill into State Gov jurisdiction at this time.
Thank you. Senator Anderson?
Thank you, Mr. Chair. Mr. Backus, you said Articles 3 through 6, is that correct?
Yes.
Thank you. So to the testifier, it talks about controlled substances being under illegal presence of controlled substance while in duty status. Is there a delineation of those controlled substances that you're pointing out along with just saying controlled substance? Is there other items that would be considered under the controlled substance definition?
Lieutenant Colonel Blomgren.
Mr. Chair, Senator, thank you. Good question. Yes, we would just follow the federal FDA rules on what is a controlled substance. We added this because currently, if you're under the influence of alcohol, it is a crime while you're in a state status. But there is no like provision if it's a controlled substance. So we wanted to add that as well, that if you do show up and you have a drug test we do random urinalysis test, and so if you do pop positive for a controlled substance under the FDA rules for what is considered a controlled substance, we can take action similar to if you were drunk on duty.
Mr. Chair.
Senator Anderson.
So, Mr. Colonel Blomgren, is marijuana considered a controlled substance? And can you test for it?
Lieutenant Colonel Blomgren.
Mr. Chair, Senator, yes, under the federal rules, it is considered a controlled substance, and we also have both Air Force and Army regulations that prohibit it as well. So it's not only a federal violation, it'd be a violation of a lawful general order.
Mr. Chair, Lieutenant Colonel Blomberg, can you
Senator
test for it?
Lieutenant Colonel.
Mr. Chair, Senator, yes, we do test for THC.
Thank you.
Senator Latz.
Mr. Chairman, I was just going to note that we did have a lengthy hearing in Civil Law Committee on this as well, so some of us who serve on both committees have already seen it.
Yep. And having said that, is there a further discussion? I am hearing none. Senator Anderson, would you make the motion?
Mr. Chair, I move that the Senate File 724 be recommended to pass and sent to Finance?
Floor.
To the floor. Okay.
Senator Anderson moves Senate File 724 be recommended to pass and move to the floor. All those in favor say aye.
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 The motion prevails. Thank you, Senator Lang.
And thank you, members and Mr. Chair.
Thank you, Mr. Chair and members.
Thank you.
Senator Latz. We're moving faster than I ever thought we were going to move. Maybe we should have more meetings on Fridays, huh? The lobbyists are saying no, no.
Mr. Chairman, there's lunch at stake here, so.
Right. Well,
That
we never
might be an
listen, we
incentive.
never listen to lobbyists anyway. Senator Latz, it looks like you have an author's amendment. Did you want to move that now, or would you like to have a little discussion first?
No, I'll move it now. I move the A1 amendment.
All right. Senator Latz moves the A1 amendment as an author's amendment. All those in favor say aye. Aye. Opposed? The amendment is adopted. Senator Latz.
Mr. Chairman, thank you for the opportunity to present this bill here today before the committee. Senate File 4040 does three things. The first section of the bill is a matter that was also traveling separately, which we have already heard in this committee, which would be to eliminate the $8 fee for downloading uncertified or getting copies of uncertified court file documents. So I'm not going to belabor the point on that. The fiscal note that's associated with this bill accounts for that and was also traveling with the other standalone bill, which the chair laid over for possible inclusion in a future, larger bill. Section 2 of the bill and Section 3 of the bill are the main reasons that this is being brought forward. Section 2 of the bill responds to or would provide a process by which all attorneys who are properly licensed and pass a background check in Minnesota would be able to bypass the security in courthouses around the state. Let me explain the reason for this. Right now, if you go to any courthouse in the state, but typically, certainly in the metro area where there's an higher volume, you will find prosecutors and public defenders bypassing the security process that's there. They wave a badge, either viewed by the security personnel, or there's an electronic badge reader that allows them just to walk right through and not have to, either to walk through the security system without stopping and having to disrobe or empty their pockets or take off their belts or their shoes, and without having to put their briefcases and other belongings through the screening devices. That saves potentially 10, 15 minutes if you're arriving at court during a high volume time. It also has the effect of sending a message, I would say, or a message not intentionally necessarily, but the effect is for a message to be sent to other members of the public, including potential jurors that are waiting to go through security, that the prosecutors in a particular case have some sort of preferred status in the system. So you end up with an awkward situation where the defense attorney in the case might be waiting in line with the public and the jurors to go through security, while the prosecutor in that very same case may be able to bypass the security and have the impact being shown preferential treatment by the system. It is, the amendment that we added would allow this to take place for not just private attorneys, but all attorneys, which means that the Attorney General's office, for example, that are not county employees, would also have the preferred status in this situation. There is a letter of support in your packets from two organizations. One is from the Minnesota State Bar Association, submitted by Brian Lake on behalf of the Bar Association, indicating that they support the provision to allow lawyers to be pre-screened for courthouse access. The pre-screening system is set up in such a way, or proposed in this bill, that licensed attorneys would be able to submit an application with a processing fee and go through a background check. And assuming that they pass, they'd be issued a card indicating their preferential status when they enter courthouses. There is an interesting twist on this provided by the courts in the fiscal note, which I'll highlight. The fiscal note was just released this morning. So I just saw it today as we're appearing here as well. Before I mention that, I will note also in your packet is a letter from the Minnesota Association of Criminal Defense Lawyers, also supporting this provision and explaining the reasoning behind that. And included in that, I will note also, and there's a listserv among criminal defense lawyers, which includes private attorneys and public defenders. And you would not believe when this issue came up, the responses that were placed on this listserv from female attorneys and some of the disgraceful treatment that they've received at the hands of security personnel while they attempted to enter courthouses and were forced to, I don't want to say strip, but for some of them, I think it felt that way. It certainly was the tenor of the listserv commentary, where they were, those who had underwires in their bras, for example, had some issues. Those who were not properly attired, according to some security officers, which had nothing to do with security screening, but they faced inappropriate comments and requirements to enter the courthouses. And so certainly for those attorneys, it was a very demeaning process. And so having a pre-screening eligibility or preferred status would go a long way toward changing that behavior as well. I'm not going to say it's widespread throughout the state, but I will say I was shocked at the number of female lawyers that said they'd had some sort of demeaning experience in going through security. And every time someone responded again saying they had this experience, it would generate another round of responses saying, oh yeah, well I had this experience too, or I had that kind of an experience in another place. So this would also address that concern. The fiscal note, which contains the court's response to that, and I believe the fiscal note is in your packet, explains that security at the courthouses are a function of the counties, not of the Supreme Court or the judicial branch itself. Essentially, the judicial branch are tenants in county-owned and operated facilities. And that makes it a little bit more challenging for the judicial branch to be involved, and probably would need some coordination with counties to make it work. I would think that the legislature does have some authority to mandate that the counties grant access to properly screened and authorized attorneys for this. But the judicial branch indicated they aren't properly staffed to administer this program because they didn't really have a good idea what would be required. They couldn't assign a fiscal cost to providing this. And so I know the bill's being laid over, and there might be some further consideration given to this. It's possible that there's some other agency like DHS that already has a background check system in place where it'd be fiscally or administratively easy to run a background check through them, rather than requiring the judicial branch to do it, but still providing for the same preferred status as security entrances in the courthouses. The amendment that we put on did two things on this section. One was to not limit it to only private attorneys, as I say, then, for example, the Attorney General's staff, or public defenders that are part-time public defenders that may not have full security screening or access in the courthouses would also be able to go through this system. The other piece of that amendment indicated that the consultation would be with the State Court Administrator's Office and with county officials in the county in which the courthouse is located. And that was added at the request of the Association of Minnesota Counties. And then the third section of the bill has to do with attorney access to court records. Right now, and we learned some of this in our conversation before about the section 1 of this bill relating to making free access to court documents. The public is able to access some court records through the MNCIS system or the Minnesota Court Records Office, MCRO system. We can type in a court file number, or we can type in a name and do a name search under some circumstances. Usually it's a court file number because name searches for pending cases don't turn up responses if you're accessing the data remotely. If you go to a courthouse, you can get it. But you don't have access to all the records in a case. So if I'm in my office and I want access to all the court records in a case, I can't get them. Not even in my own case where I'm filed as a certificate of representation. I'm the counsel of record in the case. I can't access remotely, digitally, all the records in the case. I can get some, but there are some which contain more confidential information, which may not be public. For example, a pretrial bail evaluation is not accessible to the public, and rightfully so, because it does contain confidential content. A pre-sentence investigation for sentencing also contains sensitive and confidential information that would not be appropriate for the public to access, but I can't access it either remotely. I have to rely on the prosecutor sometimes, or the court administration to send it to me. Sometimes I don't get it before I walk into the courthouse. I have to say I just couldn't access it ahead of time, even if it's been sent in 2 or 3 days before the hearing. But there is a system that the prosecutors use and the public defenders use, at least the ones who are employed by a government agency, to access all of those court records. It's the MGA, or Minnesota Government Access System. The proposal here is to allow licensed attorneys to have access to the same court records that the prosecutors have access to. It would place certainly the defense bar on equal footing with the prosecutors in terms of accessing those documents. The Bar Association did not take a specific position with regard to that provision. A letter from the Minnesota Association of Criminal Defense Lawyers does indicate the reason why they do support it. That's in paragraph 2 of their letter, which is also in the packet. It has been an urgent issue, they say, especially for COVID reasons, when courthouses where you could get these documents were essentially closed for an extended period of time. And although it looks like there may not be a strike of public defenders, there was concern that if private attorneys were required to step up And that raises a whole lot of other issues, but there was a lot of discussion about the possibility that courts might try to appoint private attorneys to step in on public defender cases. That we, if we were appointed that, and if we were to agree to essentially cross a picket line, as I would see it, to take on a case, we wouldn't have the same access to the records for the case. There's been some conversation about possibly limiting this kind of access only to counsel of record and not to have access across all court files across the state. And some of that conversation does take place also in the fiscal note, where the courts have raised a number of issues about statewide access to non-public records for private attorneys, how they would manage to oversee that, if you will. A reliable way to verify a legitimate business need to authorize access to certain non-public records, quoting out of the fiscal note response from the courts. And they do indicate that they're not sure that they could handle 25,000, up to 25,000 additional users to the system from a technical standpoint, and that if they were required to expand or somehow institute a new system for private attorney access, that could be quite an expense associated with that. And that information is in the fiscal note. So that may be one good reason why we would try to limit it only to counsel of record in cases, but you would still have to have the private attorneys go through the system to get credentialed, even if that limitation were placed on there. So I'm not quite sure how that would play out. In any case, these are issues which I would hope the committee would consider. I'm happy to answer questions and listen to a discussion among the members of the committee about this. I think they're important for us to consider, and I hope that we could find a way to make it work to facilitate the provision of our legal services as efficiently, as cost-effectively to our clients as we possibly can, and also to facilitate the administration of the justice system. Thank you, Mr. Chairman, for the time and consideration today.
Senator Latz, have you gotten any information outside of the fiscal note from the Judicial Council on whether they support this proposal or not?
I have not yet, Mr. Chairman.
All right. Well, they certainly have been made aware of it by their comments in the fiscal note. So I can only conclude that they're remaining neutral on it for now.
Mr. Chairman, from the comments that are in there, it seems that way. They've raised some questions for consideration and indicated what the expenses might be if they have to go a certain route. They don't seem to take a position for or against the concept.
All right. Any discussion? Anyone else in the audience who wishes to speak for or against this bill? Please proceed. Please identify yourself for the record.
Chair Limmer, for the record, my name is Rich Newmeister. When I saw the bill for 4040, it's just dealing with the eliminating of fees. But when I dug in it late last night, I saw Section 2. I sent an email right off, heads up, I labeled it, to Senator Latz saying I'm going to testify as a courtesy. What got my dander up was the egalitarian principle that I've tried to strive for many, many years. And as someone who's lived right across the street from the Ramsey County Courthouse for 40 years, I go into that building many, many times. After 2001, when the security came, at that time I said it's important that everybody go through it. Of course, Bob Fletcher and company in the courts, no, that was not going to happen. And so I work at the Ramsey County Court Place, not as an employee, but I go there and I work in the law library to help me prepare when I come here to debate and to suggest policy. Those things that Senator Latz, that says that happens to women lawyers, that also happens to women, regular people, who go through. I see that. I've seen it in Hennepin County. So you know, how can I argue, is there implicit bias about, as Chair Limmer, as Senator Latz, about the county attorney going by and other, I don't think so. But for me, it's just a principle that I've strived. Chair Limmer, as you know, yesterday, Rena Moran came and visited this august room, historical room for me over the years. And as I did, as you may know, I took some of her visitors for 10, 15 minutes, explaining to her about what the legislature was, this committee was. But one of those important points, I said to them, you can come into this building freely. It's an open building. You're on par with everybody. So, Chair Limmer, members of the committee, those are, you know, I come here just to say, you know, it stinks from my point of view. That's just basically, but I understand there can be reasons for it, but I just don't like that. They get access, but we don't. I have to wait in line just like everybody else does. So Chair Limmer, members of the committee, I think you know basically where I've come from on these points. But I'm glad, and I would though encourage you, whatever form it is, that you adopt Section 1, whatever bill it is, how that comes out in your omnibus. So, Mr. Chairman, members of the committee, those are my comments. Thank you.
Thank you, Mr. Neumeister. Is there anyone else in the audience who wishes to speak on this bill? Yeah, we're listening to testifiers first. We'll be taking questions after. Would you identify yourself for the record? Or Senator Latz, did you want to respond to the previous testifier?
Thank you. Yeah, Mr. Chairman, first of all, of course, I appreciate the heads-up email from Mr. Neumeister, and always welcome his input and insight on issues that come before the committee. I would agree with what he has to say. My bill is focused on attorneys because we are frequent flyers, if you will, in the courthouses, sometimes entering the courthouses many times in the same day. There may well be others who have similar experiences or would have similar need or desire to frequently access courthouses. You know, the TSA has a preferred system basically for anyone who can qualify with the background check. And if it were the will of this committee, I certainly would support a system by which anyone who can pass a background check could get some sort of a preferred status to enter courthouses without going through the screening process. But I think that would require a little more analysis. Licensed attorneys are in perhaps a unique situation, not only because our work, at least those of us who do trial work, is in the courthouse. We are there all the time. And secondly, we have a special duty and responsibility with regard to our role in the justice system. Not only to maintain our licenses to practice law, we are bound to a certain ethical standard to accomplish that. But as officers of the court, we have the same standards. So I think there is a special reason to give have additional confidence that licensed attorneys are a reduced or a no threat to the security at the courthouses, as opposed to other members of the public who also access courthouses for legitimate and bona fide reasons. But it might be rather unwieldy or cumbersome or overwhelming to create a more generalized system of preferred access.
Thank you, Senator Latz. We'll move on to our testifier. Would you identify yourself once again? For the record?
Thank you, Mr. Chairman and members. Joel Carlson here on behalf of the Minnesota Association for Justice. And we had indicated to Senator Latz's office that we would be here live to provide testimony and support, and that's what we're here to do. I do agree with Senator Latz. There's a distinction between officers of the court that are going through a background check for pre-screening to go through the frequent flyer line than the rest of us, and that does carry some weight. We support the bill, and we appreciate the committee taking time. We did testify in support on the copying fee question in the Civil Law Committee as well. Thank you, Mr. Chair.
For the purposes of the record and those listening, this bill is intended to be laid over.
Yes.
For further discussion. Senator Giffmeyer, I was told you are patiently waiting.
Thank you very much, Mr. Chair. Yes. Mr. Chair, I think one of the things when we realize that even when you have TSA pre-check, they always reserve the right to be able to screen you separately. And not only that, to do random screenings, therefore protecting us from the maybe rare but inadvertent situation that someone might wrongfully use this privilege and could potentially cause harm. And I think when they know that it is a routine or kind of situation. So in reading the language on Section 2, I'm not seeing that kind of language that would say that the entities that are doing this have the right to pull someone into a screening beyond the special one that they're given here in Section 2, and also a statement such that that because they have it does not mean that they wouldn't be in a situation like that. I'm not coming up with any language, but I do think we should have something in it, just as we do with other situations, to make sure that we have the screeners who have the ability, in case they sense that something is off or not quite right, that they have the ability legally to deal with that situation. So that's my comment, Mr. Chair, for consideration.
Senator Latz, any comment?
Mr. Chairman, I guess I'd have to think about that. I can understand what Senator Giffmeyer is saying. I don't know offhand if, for example, county attorneys who are entering the courthouse or public defenders who are entering the courthouses, if they are also subject to screening based on a reasonable suspicion or random application of a screening processes. I guess I'd have to think about that. As I understand what Senator Giffmeyer is saying. I appreciate the comment.
I would think, Senator Latz, that anyone in a courtroom or a court building would be subject to search just like any citizen would be if an officer or security official suspected that they might be carrying something of danger to the people inside the building.
I would think so too, Mr. Chairman.
So until as I said before, we're going to lay this bill over. So Senator Johnson's waiting in the wings. Senator Johnson?
Thank you, Mr. Chair. I just briefly wanted to lend my support to this bill too. When I think about that, and I've been through the courthouse a few times, and a lot of times it's some haggard, public defender or somebody working on behalf of a client, trying to get from courthouse to courthouse, especially up here where distances are great and minutes make a big difference in somebody's ability to be well represented. So I think given the background checks and the due diligence that folks have to go through to get their license, I think that it may look like we're getting special treatment, but I think it's on behalf of the clients that we represent in the courthouse. So I do like this idea of being able to get through that position, because that could really hold up somebody for quite some time. The only thing that I'd like to see is we shoehorn the state law library in this too somehow, because it's a hassle getting in there, but that's a whole nother subject. So we'll leave that for another day.
Mr. Chairman, if it will help the bill, I will certainly add the state law library to it.
Do we really want to add this, Senator Latz? Since it's such a complex issue. We can talk about that later. Is there any further discussion regarding Senator Anderson?
Thank you, Mr. Chair. I noticed in section 2, it talks about judicial district and consultation with the manager and managers of the courthouse. Has the Association of Minnesota Counties or the Sheriff's Association weighed in on this particular language?
Senator Latz.
Mr. Chairman, the Association of Minnesota Counties has, that was the basis for the one portion of the A1 amendment that included them in counties in the consultation. So I don't know if you have the A1 amendment in front of you, Senator Anderson, but that language was suggested by them. I have not heard from the Sheriff's Association. I have heard from the County Attorneys Association, and they are neutral on the bill.
Senator Anderson.
Mr. Chair, I'd like to hear from the sheriffs because they're kind of the ones that are overseeing that.
Perhaps when this bill comes back to us, we'll have an opportunity to listen to them. Any further discussion? Hearing none, Senate File 4040 will be laid over. Thank you, Senator Latz. There's no further business before this committee.
Thank you.